2022. This is the Rockport Zoning Board of Appeals. And my name is Jeff Parker. And we have a hybrid meeting today, so a lot of our council are coming to us via Zoom. Shall we do introductions very quickly? Because we don't have nameplates, so I expect the audience to memorize this. To my far left,
Kim Graffam.
Maxwell McCool.
Terry McKenzie.
Jeff Parker.
Robert
This guy here.
Kevin Olenek.
Robert Hall.
And on Zoom, why don't you guys just go through a quick little test and we'll see, make sure everybody shows up.
I'm Leah Rayson. I'm here on behalf of the Zoning Board of Appeals, serve as special counsel.
Daniel Murphy for the Town of Rockport Planning Board.
And Orion's out there somewhere.
And Orion.
All right, very good. Thank you. Couple of announcements right off the bat. We have two things on our agenda today, and the second one being an appeal of the code enforcement officer actions. That we will not hear that. Actually, I would entertain a vote to continue that to another date as soon as possible. But he is not feeling well and can't appear tonight. So do I hear a motion?
So moved.
And a second?
Second.
So Terry second, Bob motion. Any discussion on that? We will endeavor to make that as early in the future as possible for all parties.
Do we have to vote A or nay since we made a motion?
Yeah,
Okay.
we are not yet voted. That was the discussion
Okay, I'm
part.
sorry, I'm
Any
sorry.
further discussion besides Jeff shooting off his mouth? All right.
Should I be?
You're in the meeting, you're
Okay.
fully vetted for this kind of stuff.
Okay.
And starting with the far left.
So the motion is to continue it. So
Continue the second thing, yes.
I vote yay.
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 Yes?
Yes. Aye.
All right, that is unanimous. So what's gonna happen here tonight, I'll go over briefly the process. Our council.
Mr. Chairman, I'm
Yes.
so sorry. I think there may have been another request, if you
Oh,
recall.
I'm sorry, you're absolutely right, it didn't make it to my notes. The other request, and it hinges on the first one, is that since we are continuing my apologies to everybody involved. Since we are continuing the second motion, Attorney Kristen Collins, attorney for Friends of Rockport, would like us to consider continuing the entire meeting. She feels that there's some sense of efficiency in having both things heard in the same evening. And thank you, Leah, I had forgot to put that in. So any motion with that to continuing the entire meeting, and we'll go for discussion during the discussion. Any motion from the board? And remember that motions can be voted down, but
I move to continue the entire meeting to a later date.
so it's this. Oh, okay. So
That would
to
be-
give her, yeah.
To give Attorney Collins time
Right.
to
I was looking for
present all at once.
a double negative in there.
Okay. Is that a double negative?
No, it's not.
I'll second.
Second that, okay. So, purposes of discussion, anybody on the board have anything to say about that, and then we'll get to you. Terry's hand first, and then you.
Is a question to Leah appropriate?
Sure.
Okay, so I just would, as a member of the Zoning Board of Appeals, do you have any input or guidance as to whether this would be a constructive and appropriate thing to do before we cast a vote, yes or no?
Sure, I mean, I can absolutely speak to it. Of course, the ultimate decision is yours. But, you know, on the pro side, you have everybody going to be in the same place at the same time with respect to hearing both. I will say on the other side of things, I think I've seen Attorney Duchette, who may have traveled, I don't know how long his commute is. He's there in person. I know you all are here. I'm assuming that you've digested the record. What I will say with respect to the two different appeals, I don't see, aside from, Attorney Collins's arguments about efficiency and doing everything at the same time, as far as just legal analysis and the various issues at play, I think there may actually be a benefit to keeping them conceptually distinct, in the sense that they're different issues. There's some risk of confusing the issues by hearing them perhaps at the same time. But at the same time, if you believe that it's more efficient to just get them all done in one fell swoop, then there's merit to that as well. You may want to hear from the parties who are present on that issue as well.
Anybody else on the
I-
board?
I-
before-
And actually, Mr. Chairman, I don't know if you have Attorney Collins' email at your disposal. Perhaps just instead of me speaking for her, or anybody speaking for her, perhaps the email could speak for itself.
Okay, we could do that.
And if you don't have it at the ready, I'm more than happy to, I have it right here.
I should be able to plug it in. Why don't you go ahead and do that?
Okay. It says, I believe it would be more efficient and cost-effective for all to hold just one meeting, and I would so ask that you put the request forward. And that's thanks from Kristen.
Okay, right. Bob, I think you were next. Is that?
Yes. This matter has dragged on long time, far longer than it needs to be. We should get to this portion of it at least tonight and get it finished.
As a non-lawyer, these are complex issues. And I think dividing this up, it probably is of benefit to people like me who really want to focus on the details. And I think it's a very detail-oriented issue. And I think it helps by dividing these up into two different meetings. So I would rather do it that way because I think it helps us who are not in the legal profession.
And counsel for 24 Central.
20 Central Street
20 Central,
LLC.
sorry.
It's all right. I couldn't agree anymore. And in fact, I think in one of Mrs. Collins' emails earlier today, she indicated that she had already submitted written arguments, so those are before you already. So it's not like those can't be heard and taken into consideration. We've filed a response to that. I completely agree. They're totally two separate issues. One was a decision on remand from the planning board. The other is looking at the CEO's decision relative to the building permit. There are arguments that are separate on both sides. I think it's much better to take them separately.
Thank you. Any other comments? Sorry, Terry.
In addition, what I heard in the email, like, I agree with what's been said so far. It seems like she's emphasizing efficiency and cost effectiveness, and I don't think that that should be a factor that should sway our deliberation here. And I totally also support that two separate, keeping them clear. I think we're going to do a better job focusing on them distinctly.
All right, so we have a motion and a second.
Jeff, I have two
Sorry,
other
yes.
comments to make on that. Two concerns for the board to think about too is because the code officer used some of the decisions made by the planning board, there's concern about ripeness associated with the second decision. And you would have to probably go through procedurally the first one, make a decision, vote on it prior to even hearing the second. And I think that also brings up, you guys have in your bylaws or in the land use ordinance, if you hear arguments within 6 months that are similar to each other and you need to make a similar decision, that you have to vote on those differently, or they can be voided from the record as well. So that would also be a good reason to hear them separately.
All right, thank you. Any other discussion? And so calling for a vote, we'll start at this end.
Nay.
Nay.
Against?
Nay?
Nay.
Nay.
So the motion fails 6-0. Thank you, everybody. Next, going ahead with this first appeal, we do recognize that in past motions involving this matter that Kim has stepped down for conflict of interest. It's been so long, I forget why, but.
Yeah.
But in any event, are you planning to do the same?
Yes, I am planning to recuse myself from this inconsistency with the previous hearings, as well as to prevent any conception of bias.
All right, well, thank you for your service.
Right. I shall go observe.
Observe. Perfect. All right, so what is next is that our counsel, Ms. Rachin, will orient the board and the audience as to the procedural background. We'll sort of give an overview and determine that we can go forward in terms of authority, standing, timeliness, et cetera. She will orient the board as to the background and why are we here. We will go through the remand orders and go through them one by one, and at that point, that will be her judgment to us, and then thereafter, we will ask counsel to weigh in on the issues that we were discussing. One of the important things that we will do before we start the board discussion is to review the appellate standard of reviews and what it means for the ZBA review. And then we get into the meat of it. It would be at that point, we'll open it up for audience to make comments, and then we will go into the board deliberations. We do reserve and expect that we will have specific questions back to counsel. Obviously, within Attorney Collins' case, we'll refer to her letters in terms of 20 Central. We have people here, and then Dan as well is on live stream, is on Zoom, excuse me. So with that overview, I turn it over to our esteemed counsel.
Thank you, Mr. Chairman. One thing I just wanted to ask from a procedural standpoint, I know different boards do things differently. If you, before I start launching into my overview and we get into the merits, is it something that you wanted to just briefly address the jurisdictional issues with respect to standing and jurisdiction and timeliness? In the event that you find that those things are not met, and maybe you don't want to listen to me yammer on too long, I think that might be, you might want to make a determination on those issues to see if we should be proceeding in the first instance.
Yeah, absolutely. I obliquely referred to that as being the next step. He says, trying to get himself out of trouble.
So, I mean, I can leave the board through this if you find that appropriate.
That would be fine.
Oh, okay. So with respect to the jurisdiction of this board, section 703 of the ordinance, land use ordinance, talks about this board's powers and duties, and it does enumerate under 702 that you have the authority to hear and decide if there's an alleged error of any order, decision, or determination by the code officer or the planning board. And I think it's fair to say that here we're dealing with an alleged error of the planning board, and therefore I think it's, obviously it's your determination, but that this board has jurisdiction in that regard. I don't know if your process is to make a motion on that or just simply state that in the record and they'll show up on tape. I don't think that's that hasn't been disputed anywhere, so if you're okay with it, we'll just note that in the findings.
I'm willing to notate that in the findings.
Okay, and with respect to the standing issue, I think this bears a little bit more discussion, but as you may recall in past cases dealing with this particular approval, there have been appeals by the same parties, and it's been a group, I think, referred to as the Friends of Rockport, and it talks about who some of the members, at least, of that entity are. And while there may have been some concern about the actual, whether or not some of the folks meet the legal definition of standing, there's at least one, and I believe it's Mr. Priestley, who lives in such close proximity. In fact, I think it's across the street, that in my view, that would satisfy the requirements of standing. That has been your past decision, and just would like to allow that into your report to make sure that that's still something that this board feels comfortable with, and that we can note that accordingly in the finding.
Again, by a claim, we'll proceed that way.
Yes.
Yes.
Okay, I see a lot of nodding, so I'll move on. And the next issue, of course, is timeliness, which is always another issue. And under your ordinance, it requires a 30-day time period. That's the deadline by which appeals must be taken. Looking at the record here, it looks like February 3rd, 2022 was the date on which the planning board voted in their post-remand decision. And it also looks like this appeal, as I see it, was filed on March 7th. 30 days falls on March 5th, would have been a Saturday, but under the rules, the governing rules, I believe that the deadline would fall on the next business day, which was the 7th. So it just looks like there's support in the record to find it that the appeal was timely. But of course, the board has to do that.
So do you suggest that we actually make a motion on the timeliness, or we can?
Yeah, I mean, I think perhaps on all of the issues that I just mentioned are jurisdictional issues, so maybe you might want to take a motion that, that the board finds that the required jurisdictional requirements have been met under the ordinance.
I think I hear Bob saying that.
So moved.
And a second from
Second.
Terry. All right, any discussion on the moving forward? Hearing none, voting?
Yay.
Yes.
Positive.
Yes. Aye.
5-0 and good, thank you very much.
Excellent, yeah, and I'll just note for the record that, you know, the reason I was leading the board through this is because it seems like there's no dispute as to those issues in any event. Okay, so, Mr. Chairman, you had asked me sort of to set the stage, so to speak, as to why we're here, procedural posture that's brought us here, and then to give an overview of the various post-remand orders. And so, without further ado, I'll do that. So, you know, as this board will recall, you have seen me and you have seen the parties here several times with respect to various approvals relating to this project. And as you know, this approval has generated a couple of lawsuits. One from the planning board site plan approval, and the other from the code enforcement officer's issuance of a building permit. And so what you should know is that the court consolidated those two cases, and which resulted in a number of court orders that explain the salient points of each of those cases. And so what I'm going to try to do, hopefully, is to explain to you how those decisions actually frame, and I would say limit, this board's job tonight. I would say that, and I'm going to go through that, but as I think Mr. Chairman mentioned, that because that is such an important issue, that before we actually get into the merits of the appeal, I think it's important that the parties have an opportunity to weigh in on whether I have appropriately teed up or described those remand orders, and if they have any disagreements or other comments to add to that. I think it's important to say, without being disrespectful to the court, that the orders themselves, and particularly the way they dovetail with each other, I think are not necessarily as clear. They're not as a model of clarity, and I think there is a bit of confusion around that. But I am going to do my best to tell you my thoughts on how those remand orders directed the planning board's analysis, and therefore, by extension, what your job is to do today. But let me just, very basically, how did we get here? So, as you know, on February 27th, the planning board voted, not February 27th, 2020, I should say. The planning board voted to approve 20 Central Street's application for a 26-room hotel and restaurant. Given the pandemic, those findings were not actually issued until May 21st of 2020. The planning board decision was appealed to this board, as you'll recall, and this board denied the appeal and upheld the planning board decision, and that was on January 21st of 2021. Then the Friends of Rockport appealed that to the Superior Court, and the court issued a remand order on December 1st, 2021 to essentially go back, kick it back to the planning board, requiring the planning board to make additional findings on two things. First, whether the land use ordinances standards with respect to parking were met, and with respect to architectural standards. So in my view, I read the remand order to look at those two things. Then on January 27th, the planning board actually did go, they actually had a site walk, they heard from the parties, they took some additional evidence, which that is an issue that we'll be talking about whether or not they should have done so. And then the meeting was continued to the 3rd of February of this year, where the board met again to consider draft findings, and they voted to uphold the planning board's original decision, making more fulsome, robust findings based on two things, and this is also important. Because there is some issue as to whether or not it was appropriate for the planning board to take new and additional evidence, the planning board's findings, the post-remand findings, were essentially bifurcated. They made one determination based on the post-remand record, meaning they just looked at the existing record as it was before them in their original case and their original findings, and gave additional findings in support of their original, in addition to their original findings, per the court's instruction to have better, fuller, more detailed findings. Then, and they made very clear that these secondary findings, their supplemental findings, were based on the new evidence, but only if and only if it was deemed or is deemed by the court to have been appropriate to consider this additional evidence. And so you will see, and you probably did see in the findings, that they did clearly distinguish between pre-remand evidence and post-remand evidence. So as we consider this, and as you consider whether or not the planning board got it right, I think it makes sense to also bifurcate that decision. But we'll talk more about that as we go along. So I'm going to get to the remand order now. And it's, again, I set this up before, but it's really important to understand that this remand order deals with those consolidated actions, the ADB, and I'm going to call it this ADB appeal. That's with respect to the planning board. And then there's this CV action. So there's alphabet soup, ADB, CV. ADB is the planning board's decision on site plan approval. The CV action is with respect to the building permit issued by the building permit issued by the code enforcement officer. And so to summarize, and it's important to understand that as the court did its analysis in all of these orders, it kept the two conceptually distinct. So with respect to the ADB, the major issues were parking, maintenance of scenic views, and architectural harmony. And with respect to the CV order, again, that's back to the code enforcement officer's issuance of the building permit. That was whether or not he erred in issuing the building permit for a 26-unit or 26-room hotel based on the two petitions that were enacted in August of 2020. And if you'll recall, there were two petitions. One, petition A, I'm going to refer to it, was with respect to a traffic study that was mandated if there was going to be off-site parking, shared parking, or a waiver of parking. So that was the first petition. It's important to note that that petition, by its own terms, it said it would be applicable, and I'm just reading it, to all land uses and off-site parking facilities that had not received final approval as of 40 days prior to the amendment enactment. Now that's critically important, at least from my perspective, because at the time the planning board made its original decision in May of 2020, these, petition A had not been enacted. It was enacted in August of 2020, which is more than 45 days after the site plan approval was approved. The second petition at issue was petition B, and that was with respect to the number of rooms. If you'll recall, this was approved for 26 rooms. The petition that passed and that was enacted in August of 2020 limits rooms to 20. So that has a little bit different applicability, and by its terms, that applies to all hotels and inns that have not received final approval and building permits as of March 1st, 2020. Now, it's important to note that the building permit was not issued for this particular project until March 2021. So what are the upshot of these various orders and how do they dovetail? I'm gonna go through that. So with respect to parking, the court basically based its findings on, there was agreement, and it's good to hear that there's agreement on some issues, and the agreement is that this project only required, not only, but it required 56 spaces. Everybody agreed on that, 28 for the hotel, and 28 for the restaurant. And as also, as you'll recall, that was met by some within the Sandy's Way lot, and there were 21 spots that were in the Sandy's Way lot, and 35 spots were off-site. I think as I recall, it was referred to as the Hoboken lot. So from the Friends of Rockport perspective, they believe that the permits and waivers that were already granted for the Sandy's Way lot resulted in an oversubscription. Too many parking spots, and therefore there were not enough available for 20 Central Street's application. The contrary view by the town in 20 Central Street is that there were actually more than enough parking spots. And so what happened here is that the court found that the planning board's findings in this regard, with respect to the sufficiency of parking, with respect to the waiver, the supposed waiver, or I shouldn't say supposed, the planning board back in 2012 granted a waiver to Union Hall with respect to parking. And so the court said there wasn't enough discussion about what that waiver actually meant, what it was based on, and also the competing demands of businesses and the general public of parking. And so it directed in its remand order to give a better, more robust discussion of the evidence on which they based that decision, that there were sufficient parking spots. With respect to architectural harmony, that's the second issue that was at issue in this ADB. As you know, the Friends of Rockport alleged that there were design conflicts with the surrounding properties in the surrounding area. I will say that while I think the Friends of Rockport had outlined several concerns they had with respect to architectural harmony, the remand order, the court says, and I quote, while the Friends of Rockport presented a list of objections, they now confine their challenge to the balconies that extend from every guest room on the front facade. So I think those words are important because we're talking about only the balconies being the issue with respect to architectural harmony, and also it's with respect to the front facade, not the back of the building. And so I think that's important to guide you going forward, that the court order limits the consideration of architectural harmony with respect solely to the balconies and solely to the front of the building. I'm sure the parties may have different views on that, but they'll have the opportunity to speak. Another reason why the court remanded back to the planning board is that they faulted the planning board for not being more specific about why they found the architectural harmony standards to be met. And so they wanted further findings on whether the balconies were in the field of vision of a person standing on Central Street. And I'm not sure if that field of vision actually appears anywhere in the ordinance. I don't think it does, but that was the interpretation, because I think the ordinance does speak about surrounding properties, neighboring properties. So that's something that you should think about. Also, the court wanted more information about how the balconies might blend with or complement or clash with the buildings on 20 Central Street. So we've talked about what the remand was with respect to parking. We've talked about what the remand was with respect to architectural standards. The other issue in the ADB case was with respect to scenic views. If you'll recall, there was objection to how the fact that the hotel took up pretty much the entire block, blocked the view of the harbor. And the way I read the remand order and subsequent orders is that the scenic issue is now dead. The court found that because of the provision in the ordinance that basically allows buildings with frontage on Central Street to have maximum lot coverage, that precluded any further conversation about scenic view. And I believe that that Friends of Rockport asked for further clarification on that issue, and in a subsequent post-remand order, the court reiterated that in its view, that scenic view issue was no longer before the court. So because of that, I think that it's no longer before this board. And the one piece that I did, so I think there is clarity that the remand orders basically limited the planning board's findings or remand considerations to traffic, to architectural standards, not to scenic view. But I think there is a point that I need to raise where there's some dispute about what the scope of the remand was with respect to parking, okay? And I know that the town is here and the developer is here and they can speak to that issue better than I can, but because Attorney Collins isn't here, I think it's important that you understand what the Friends of Rockport's perspective is on this. So I think fair to say the town and the developer believe that the remand for consideration of traffic standards has nothing to do with the petition requiring a traffic study. I think what Attorney Collins was arguing is that in the remand order, it actually says, and I'm going to read from the remand order rather than editorialize on it, I'm going to read from it. So in the remand order, it actually says that the court declares that the amendments set forth in petition A and petition B that were voted in August 18th, 2020 apply to 20 Central Street's applications for a building permit. So if we stop there, I think it is clear that it only applies to the code enforcement officer's decision, the building permit. And it does not require the planning board to then go and do that analysis of, do they need to have a traffic study, and is that traffic study consistent with the traffic requirements? If it ended there, I would say that it's very clear that only the code enforcement officer must do the analysis of the traffic study. However, there was a subsequent order called a further order and judgment, which was dated January 3rd. The original remand order was on December 1st. This order that I'm now going to read from is January 3rd. And in that further order, it states, the planning board will have to review the parking elements of 20 Central's application in conjunction with the court's judgment on count 1 of CV. And what count 1 of CV found is that the petitions applied. So I think it's really important that we hear from the parties regarding whether or not they think that the planning board has to consider this traffic study, and without a consideration of that, it does not meet the traffic standards, or if that traffic study only need be considered by the code enforcement officer in the context of the building permit application. So I think that's an important issue that I don't think is a model of clarity in the court's remand orders. Now, I think the second component of the remand order is back to this CV, not the ADB that we talked about in detail, but the CV order, which is with respect to the code enforcement officer. As you know, Friends of Rockport argued that the petitions applied to the hotel, but the court articulated a critical issue that I'm going to just read it to you. It talks about, in light of the timing of the enactments of the petition, the question here is whether the planning board site plan approval does that entitle 20 Central to the right not only to build the hotel with the specified outer dimensions, but also the specific hotel contemplated, including the interior configuration. So, trying to distill that down to its essence, the question becomes, we have a site plan, we have an approved site plan that contemplates 26 rooms, right? We know that the court has said that the petitions apply to the building permit. So the court says any building permit would have to be only for 20 rooms. But the court found that the developer is not entitled to vested rights in a particular building plan. So basically, I think what the court did was uncouple the two analysis. I think what the court did was basically to say, look, you have your site plan approval. Yes, it's based on 26 rooms, but what it said is that in a site plan analysis, there's really no consideration or analysis of the interior. It's really about the exterior. And the court specifically said that, the planning board's reference to a 26-room hotel, and I'm quoting directly, appears to have been a repetition of the applicant's description rather than an element of the board's evaluation. And so I think what that means is that the site plan, yes, it contemplated 26 rooms, but that in and of itself is not a violation of the petition, because bottom line is that petition was enacted after the approval, whereas the petition with respect to the number of rooms was enacted after, the building permit was originally issued. So at this point, I know that's extremely confusing, trying to make it as clear as possible, but trying to distill it down to its essence, your task is as follows. You look at what the planning board ultimately decided post-remand. You look at the issues regarding traffic and parking, and you have to decide if the parking issue is limited simply to the number of spots available and the waiver and the competing needs of the various businesses in the general public with respect to use of that Sandy's lot, and that is the scope and the limitation of the scope of the planning board's consideration, or if you believe that the planning board was also required to consider a traffic study under the petition A. With respect to the architectural standards, your task, I believe, is limited to simply determining whether the balconies met the architectural standards, whether they were harmonious with the surrounding neighborhood. And there was an issue that arose with respect to architectural harmony of the back facade. I think, as I mentioned earlier, that the court foreclosed that analysis. And with respect to the scenic view, again, I believe that issue has been resolved, and that neither the planning board nor this board can make any further consideration of that. So as you move on to the substance of the appeal, and what I'll do is I'll simply enumerate what those grounds are, let the parties speak for themselves with respect to what they are, but I think it's important to talk about the standard of review before you get into it. Now, as we said, Mr. Chairman, I've been talking a lot about these remand orders. I think you've got two parties here who can speak for themselves and perhaps give you their views on how these orders shape and limit this board's review this evening, and maybe this is the time to do that.
Mr. Chair, could I ask two questions?
Yes, please.
Yes. Leah, I'm sorry. I think
Yeah.
you've done a remarkably good job at summarizing this matter. As you know, I'm a lawyer with a few years of experience. So I have two questions for you. One is that the Superior Court remanded certain issues, as you noted, to the Planning Board. Now, the appeal that's come to us has those issues plus a number of other issues. Now, are those other issues, that is, issues that were not remanded by the Superior Court, are those properly before us?
As a general proposition, I don't think so. I think that that's exactly right. But I think where the analysis has to happen is whether or not those issues were properly within the scope of the remand. You know, sort of hearkening back to what I was saying before, yes, the planning board, the Superior Court remands back to the planning board to consider traffic. Okay, I'm sorry, not traffic, parking. Now, what does that mean? What is the scope of that parking remand? Is it only with respect to, and as it said in the first remand order, with respect to waiver, what does waiver mean of the Union Hall parking requirements in 2012? That is clear, that is part of the remand, at least it is to me. What is also clear about parking is that the judge wanted to hear a more robust analysis, or see a more robust analysis about the competing demands of the various businesses who use that Sandy's lot and also the general public. Again, to me, that's clear. What is not clear, and this is part of your job, is to determine whether or not that parking analysis requires the planning board to look at the traffic study that was generated. That the code enforcement officer looked at, but does the planning board also have to look at it? But with respect to issues that were not remanded, like scenic view, and like anything else that is outside the scope of that, the parking and the architectural review standards, then I agree with you 100%. That's outside of the scope of this board's analysis tonight.
Okay, thank you. Second question. There's absolutely nothing in the Superior Court orders that require the planning board to bifurcate their analysis in terms of time, in terms of these issues. And I'm curious as to where that effort came from. Is that just a belt and suspenders effort, or is there something in the law that I'm not aware of?
Yeah, that's a great question, and I think I don't know the answer, the actual tangible answer, what the thought was behind whoever drafted these findings. I did not do so, but I think that there is, just in the case law, I know Dan will speak to that, but it seems to me that there's a case that actually the judge cites, I think it's Lamar v. Town of China, and that talks about remands and what's the proper scope, and it's always been, for me as a municipal attorney, unless the court specifically states, I want you to take additional evidence, that the default is, the requirement is simply to look at the pre-existing record. Do not supplement, and tell us why you made the findings based on that record. Now, I will say that in this particular case, reading through the judge's remand order, in some places it feels almost like an invitation to give additional evidence, but yet he then cites the town of China case that I just mentioned that talks about how, at least as I read it, that you don't reopen it. So I think there's sufficient confusion as between the default in case law and actually certain statements by the court about, hey, it seems almost an invitation to give or to take new evidence, but not an explicit requirement to do so, that I think that is why the findings were bifurcated that way. But Dan's here, and I don't know if he drafted the findings or Phil Saucier did, but they can speak to that.
Yeah, I'd be happy to address that if desired. So both parties submitted additional evidence to the planning board, and there is some ambiguity from the court's orders with respect to whether it wanted additional evidence or not. And so in light of the dual submissions of new evidence and the court's order, what the planning board did in an abundance of caution is it looked at the existing record carefully and then sought to find evidence to support its findings and identified those on the record in the hearing. And then, and only then, it considered the additional submissions, that in the event that additional evidence may be considered, in this situation, we consider these additional items that were submitted. And those are described in the planning board decision, which has parts 1 and part 2. So the decision itself is based on the original record, but there is additional discussion of what the planning board would rely on if it's able to consider additional evidence that was submitted by the parties. Basically, at the invitation of the parties to consider new evidence.
Thank you. That answers my question.
And was that, you said you had 2. Did I answer both of them, or were both answered?
You did.
Your satisfaction?
You did a very good job, too.
Great.
We have a quick question from Terry.
I had an additional question about what the remand requires. You've identified that the planning board was supposed to, review parking. under that parking umbrella, I thought I bumped into language in regards to landscaping requirement. Could you clarify that for us, whether that was also going to be a component for review, or did they say no? I was.
That's a great question. Terry is always a careful reader of the voluminous record here. I think what you may be referencing is the court's further order and judgment. As noted, the first remand, the thing that I'm referring to, and I think other counsel are referring to as the remand order, is that original order from December 2021 that was 20+ pages that went through this in great detail. But then there was a subsequent further order and judgment that stated January 3rd. And I think that's what you're referring to, because there is a provision in that order that talks about off-site parking. And I'm just going to read it. Terry, it says, in its decision of December 1st, the court stated that the need for landscaping at the off-site lot has been resolved by agreement, and that council disputed this. But what the court basically said is that we're not going to deal with this right now because, and I'm reading from the decision, because the judgments in these joint actions require remand to the planning board, and because the subject of parking falls broadly within the scope of the remand orders, the officials will have the opportunity to review all elements of off-site parking. So I really would like to hear from council on this one, because, you know, I know their position is that, you know what, and as long, it's only, at least I think their position is that the remand was only limited to numbers, shared parking, whether it was shared parking. But this seems to indicate there's a little bit broader scope on the remand. So I'd like to hear from council on that.
Leah, I can point you, I think, to the December 2nd document, it's page 13, the bottom paragraph. If you read that bottom paragraph, I think it'll answer the question that Ms. McKenzie had.
Could you read that out loud, please? I've got the documents, but.
13, page 13?
Page 13 of the December 2nd order and judgment. Last paragraph.
That's the first order, not the further.
That is correct, that is the first order.
Right, and that's actually where I first bumped into it, and I didn't feel that the further orders clarified it for me. So thank you. Let me just read that.
Bruce, you want to take that to screen?
Just for everyone's benefit, I think it might be great to read on the record, talk about the town appears, is this the?
That is correct.
Yeah, the town appears to have conceded plaintiff's argument that the proposed off-site parking lot is subject to the land use ordinance's landscaping and design standards. The court will therefore not address that issue, but limit its ruling to the number of parking spaces as discussed. And on that issue, the plaintiffs are entitled to relief. But then we go to that subsequent order where there is that language where the court says, because the judgments in these joint actions require remand to the planning board, and because the subject of parking falls broadly within the scope of the remand orders, these officials, meaning the planning board and the code officer, will have an opportunity to review all elements of off-site parking in the context of their further deliberation.
So can I ask a further question? So it seems like they're saying that's not coming from us. That's already been decided by the town that will be included in the subsequent planning board review. Is that the basis for review of landscaping? Like, is it something we have to watch out for when we're casting an eye, reviewing what the planning board did or will do?
I think Dan has his hand up. I'm happy to just stand back.
Just to provide some background, I believe that the off-site parking lot is owned by another party, the Vulcan lot, and it's a pre-existing lot. It's been used for parking. And there was an argument that it was a new lot and had to have new shrubbery or something like that. That was one of the arguments that was raised. But I believe that the process for that is actually the burden of the owner of the lot, not 20 Central. So it's not really a live issue, at least from the town's perspective. And so that reference to agreement with respect to the shrubbery issue was one that I objected to and said, well, we didn't agree on that. It's just that it's not before the court, because that's really an issue for the owner of the lot when it's time. It really wasn't ripe at that point. And I think the court's determination that further order was, I'm not really sure what what the plaintiffs are actually looking for at this point. It's just sort of kicked along, but I believe that that's the status of it. It's an issue for the owner of the lot, not for 20 Central.
And I think that actually, if memory serves, that was consistent with one of the planning, I think it was the planning board finding in one of the prior appeals that basically said that that is an issue for another day because that parking lot has yet to come before the planning board for approval. At least with respect to landscaping and such. Dan, is that consistent with what you're saying?
It is, and I think it might even be the ZBA that gets to determine that. So.
I think it used to be, but then I think it's been amended subsequently. I could be wrong on that, but.
Yeah.
In other words, this is not a remanded issue. It just says that however the owner landscapes it is subject to the LUO.
I just want to know whether the ZBA has to keep an eye out for that when we're reviewing whatever the planning board does. Is that up on the blackboard that we should, whether we're reviewing tonight or in the future, that somehow either by agreement, the court is saying it's not coming from me, it's already in there, and this is the shape of the elephant, but to me it's not really clear, and I just want to know what our responsibilities are, not what the salient arguments are that does the planning board have to address that at some point, and will the ZBA have to look out for and ensure that that is reviewed or not?
May I offer a suggestion?
So I'm hoping to maybe make that a little simpler. My understanding is that what it may have, I don't think it was part of the remand because that was an issue for another day. Looking through the planning board's decision that is being appealed and that is before you, I'm not sure that was an issue, but most importantly, what your job is tonight is to look at the 8 grounds of appeal that the Friends of Rockport have put before you. And as I read them, I do not see landscaping or the failure to address landscaping as part of their appeal. So God forbid, maybe it comes back to you another day and in another iteration of this case, but as I read the 8 grounds of appeal, and understand, and at least in my view, that when somebody appeals something, if they don't specifically state the grounds of their appeal and included in the grounds of appeal, that those issues are waived.
Okay, thank you, and that's
Yeah, sure.
clear for me anyway.
And Attorney Doucette, do you want to add to that?
Exactly my argument.
Great.
Oh, I'm sorry, was somebody adding more to
No,
that?
that's right, you stole his thunder.
Oh. Okay, all right, so I've almost lost the strand of where we are. I think we were about to launch into the substance, and I wanted to discuss with you basically just a little quick reminder about the appellate standard review and what that implies for this board's job tonight. Is that where we're at, Mr. Chairman?
That's a fine place to be, and we just want to say for those people in the audience who might want to say anything, we will be, where the heck are we?
Oh, you know what? I'm not sure we did. I know that we talked about the possibility of affording the parties an opportunity to discuss the scope of the remand and how that informs your task tonight. I'm not sure if they had that opportunity or wanted to take that opportunity, but now I think would be the time to do that.
Let's, and I'm looking at the screen where Daniel is and Mr. Doucette. Is there anything said so far that you either want to expound upon or take issue with? And then we'll have to go through Kristen's stuff to make sure that we've addressed it on her behalf. I'm sorry, yeah, go ahead, Daniel.
So just, there was a question raised as to whether the planning board should have considered the traffic study. And I think it's important to remember that this planning board decision was not vacated, it was remanded on narrow issues. And so you've got 2 different actions, the ADB action which does not have anything to do with petition A and petition B. It's a challenge to site plan approval. And then you have the CV action which says, hey, you better apply these petitions to this hotel project, the project writ large, not just a particular process. And if you look at the decision of the court, it went to great pains to separate those two items, site plan review and then also the building permit approval or denial process. And so petition A and petition B have been and will be applied to this project through the building permit process. But they were not applied back at a time before petition A and petition B existed, and they should not be considered today because it's just not part of the process. It's a separate process according to the court's orders, and what we are looking at is just a simple remand of two areas, parking issues, parking spaces, and then architectural harmony. And I'd say for the parking space issues, there are two subsets. One is the waiver issue, whether waiver means waiver, or whether waiver meaning excused from the requirement, or whether it means dedicating the spaces, whether the word waiver means dedication of spaces. And then there was the issue of whether Sandy's Way is a shared parking lot, meaning shared with the public. And so to the extent that there's an argument that a traffic study has to be considered to determine whether the lot is shared with the public, I don't think that that's the case at all. And I think that the planning board did address that the spaces are allocated for the sole owner of the hotel project and that it has the power to control its own parking lot. And so to the extent that there's someone who parks there to have a coffee or to run an errand at a different place, the project will have the ability to monitor its own parking lot. And so with respect to the burden of the sort of shared public parking, I believe that the planning board actually did address that. And so there's no need to look at a traffic study to do that.
Certainly. So just to add to that, I think the question for you today in relation to the court's order, what doesn't appear to be before you is the March 3rd, 2022 order on the post-judgment motions which were filed by all the parties. And in there, the court said, and I'm quoting from its second page, the court said, to direct the town's management of the issues on remand would require the court to install itself extra-legally as an ongoing referee of municipal processes. So the court recognized the fact that in some instances here, the planning board and the CEO would have to make their own decisions as to what they were going to decide and not decide. And then if you look at your own zoning ordinance as it relates to the traffic study, and which is conveniently left out of the orders for some odd reason, but in that zoning ordinance, section 803.1, it says the CEO or, not and, or planning board shall be the reviewing authority for the traffic study. And so in this particular instance, the planning board, and it's up for you today on whether or not the planning board committed clear error in this regard, but the planning board decided that it did not need to consider the traffic study, that would be an issue before the CEO.
All right.
Okay, so, again, I don't want to shut off the parties if they have anything else to add with respect to the remand orders and how that informs our discussion this evening.
So I think, anybody want to add anything to what's been said so far? I think we're pretty much up to that point.
Okay. And so at this point, I think because we're about to launch into the substance, what I'd like to do, with your permission, Mr. Chairman, is just to go over the standard of review that governs here.
Yes, please.
Okay, and I don't think there's any dispute that under the ordinance, under sections 705.1 and also 1307, that the governing standard of review is appellate review. So what does that mean? That means that this board is not taking new evidence. It's limited to the record that was before the planning board. And what the task is, and I'm just reading right from the ordinance, is to determine whether the planning board has made an error of law, abused its discretion, or made findings not supported by the substantial evidence in the record. And that standard, again, is not, is reiterated in section 13 about whether the planning board's decision is supported by substantial evidence in the record. So what does that actually mean, substantial evidence in the record? It sounds like it has to be really big, and I know people are thinking about the various, burdens of proof that you hear about, that, beyond a shadow of a doubt or preponderance of evidence. And I think it's important to understand that substantial record evidence is not that. Basically, what substantial record evidence is that it's evidence sufficient that a reasonable mind could, that the conclusion could be supported. And so the task is not to determine whether you agree, whether you, and even if, this is important to understand, is that even if, based on the evidence, you could come to a different conclusion, that's not the standard. Basically, what your job is to do is to see if the record supports the conclusions made, even if you don't agree with it. So that you're not here to assess the respective merits of the evidence. You're basically to look at it and to say, is there enough to support the decision that was made? And that's basically the standard. And so with that, I'm happy to answer any questions on the standard of review if you have those. If not, I think what would be possibly helpful is for me just to outline what the 8 grounds of appeal are. You have Attorney Collins. I think her original appeal is dated March 7th, and then there's a subsequent letter actually that outlines each one, dated April 11th, where
So this is Jeff. I just wanted to say that let's go through this where we're essentially summarizing and characterizing the Attorney Collins request, and then we'll open it up to comments from the public. I just want people to know what's coming up because we'll have set the stage enough at that point for people to react to things, and then we'll go into our substantive conversation. Thank you for allowing me to interrupt.
Mr. Chairman, can I raise a question, please?
Sure.
Leah, in the original statement of appeal and the restated letter from Attorney Collins, the descriptions of the points of appeal are somewhat different.
I'm sorry, say it again, the description?
The way in which the points of appeal are described are somewhat different between the original appeal and the more fulsome letter that she provided. Which do we focus on? The original appeal?
I think that when I'm not quite sure when you say somewhat different. I need a finer point on your question, but I guess what I would say is that when I think about a notice of appeal, that it's really just a bare bones skeletal, here are the bullet points, the basis on which we are appealing, because it's important to set those out, because if you don't, then you waive them. But that subsequent submissions to round them out are a fuller conversation of those. So I don't know if you're suggesting that there's a direct conflict between the two. So maybe if you could point to an example that might be more helpful, and I can answer it more specifically rather than the abstract.
Well, why don't we do that when we go through the individual points
Okay.
of appeal? That would be easier that way.
Sure, makes sense. So, Mr. Chairman, I think what I will do, and to your point, I will, Mr. Hollett, that I'm going to just read out the ones from the original actual notice of appeal here, or the appeal application, I should say, which was dated, I think, March 7th.
2022, yeah.
Yep. So I'm going to outline those, and then, as we go through them, I think I outline them for you, and then give the parties an opportunity to weigh in, and maybe you can raise those concerns or possible areas of conflict as we go through the individual elements. Does that make sense?
Yes.
Okay. So with respect to the first ground, it basically says that the planning board should not have held a site visit and should not have received or considered new evidence related to the scenic view or architectural harmony. That's something we talked about just a little bit earlier with respect to whether it's advisable for a administrative body on remand to hear new evidence. We talked about that a little bit. I'm sure the parties will have their submissions on that. I think we heard a bit from Dan Murphy already on that. The second ground would be, and these are all things that, you know, I think as we go through this and as findings are developed, that we want to specifically address each and every one of these things. So the second one being the planning board erred in determining that the 2012 approval for Union Hall did not rely upon the 25 spaces being added to Sandy's Way by the developer to serve the proposed use. And then she references certain record
Announcement
evidence.
media,
The third ground would be the planning board erred in failing to apply the shared parking standards applicable to the hotel and to consider the competing demands on Sandy's Way lot as required by the land use ordinance and the Superior Court's order. Number 4, the planning board was required by the court's order and by the land use ordinance to review a parking and traffic study in conjunction with its consideration of parking on remand by the Superior Court and its conclusion that the parking requirements are met without considering the parking and traffic study is not valid. Again, we just talked about that a bit. Number 5, the applicant is prohibited from building a 26-room hotel approved by the planning board, and any further consideration of this project, even on remand, required site plan amendment showing the reduction of the number of rooms from 26 to 20. Number 6, the planning board erred in failing to consider the architectural harmony of the back, i.e. harbor side of the hotel. Number 7, the planning board erred in considering a fire escape and residential deck as being architecturally similar to balconies in the hotel design. It is the number, size, location, design, and use and lighting of the balconies that make them dissimilar to any other decks or balconies in the visible surroundings of the hotel. Other balconies built after the hotel's approval should not have been considered. And the last ground is that the planning board must revisit its findings on scenic view, which is one of the considerations required by the architectural harmony standards and the land use ordinance. The required reduction in room number changes the analysis of whether the building design minimizes the impact on scenic views to the extent reasonably practicable, or practical, I should say. So those are the grounds for appeal. Seems to me that probably the most effective way of going through this is just to have the parties weigh in on each and every one of them. I'm in the chair's hands when it comes to the fact that, you know, we have Attorney Collins' submissions on behalf of her client. I'm not quite sure it's appropriate for me to be summarizing them. They're fairly short, and so, you know, the board has her submissions. I am wondering how the chair wants to proceed with respect to, you know, if we discuss those submissions in the April 11th letter, or if we let them stand for themselves and on the assumption that all board members have already read those. They
Well-
can ask any questions they have.
I think we have not only the board members, but we have people following along, both simultaneous to this temporarily now and then in the future. So I think that even though this meeting is likely to run long, that it behooves us to appoint somebody, if you will, to read the letter of April 11th, the sections that are appropriate at the time, because it just makes for, even if we've all read them and highlighted them and what have you, it makes for an even-handed conversation. So, but having suggested that, I turn to the board to see the will of the entire board.
Can I play devil's advocate?
Please.
I guess I would say that Attorney Collins had a chance to be here to present her side, or could have sent someone to present her side, and that hasn't happened. So playing devil's advocate, I would say, why aren't, if it isn't important enough for that to happen, why are we taking that role?
Yes, Terry.
I also feel that the letter of April 11th, you know, it was available to all of us. It's very detailed. It lays it out. I don't know what she would add were she here, other than to field questions. I think the the printed copy, the written copy is sufficient from her side for us to do our deliberations within our, standards we have to meet.
Max, anything to add to that
No, I agree.
conversation?
I agree. I agree with what's been said.
So let's formalize it, and take a vote, to see, that feels appropriate. Yeah.
Mr. Chairman, if I might just say one point of order suggestion, is that, we do have the submission. I hear people saying sufficiently detailed, and she set out her argument. She herself, in her email, I think, to this board, indicated that her written submissions would stand in for, those arguments. But I think in the interest of fairness, perhaps an acknowledgement or, a statement from board members that they've received it and they've actually read it, would probably be great to have for the record.
All right, in lieu of a vote, do you think, or, we have a pretty clear consensus of the board. So let's just make individual declarations and/or hold up all your notes on it. Starting with Bob, you feel that we can get by with the written word?
I've reviewed Ms. Collins' letter of April 11, along with all the other records, all the other materials in the record here, a number of times. And I'm confident I understand what she's saying.
I as well have read the April 11th, 2022 letter outlining her reasoning for all of the appeals stated, and I feel confident that I understand and don't need anything further.
We've got Exhibit A and Exhibit B. The
color
March
on it.
7th appeal. Yeah, no, I've even got
Oh, there-
stickies. Underlined, notated, poured over, hopefully absorbed correctly. Thank you.
I've reviewed the appeal as well.
Well, as have I have lots of yellow highlighters on there. So why don't we proceed with allowing the record to carry itself, and we'll go on.
Great. Okay. So I think perhaps we can just ask, Mr. Chairman, I think perhaps the appropriate order is to ask the applicant first to make any submissions they have with respect to each one. I think we go through each one individually, invite the applicant to address it, and then also Attorney Murphy on behalf of the town, if that you think is the appropriate order.
Yeah, and I'm sorry, and I did forget, we do have members of the public here, and I'm horribly remiss in not identifying. I think we had identified this as the time where we would hear public comment and then get into the serially into the individual aspects. Does that sound reasonable, Ms. Rachin?
Sure, or absolutely, or you might want to wait until the end because something may have come up during that conversation that they might want to address. Either way, whatever you think is appropriate.
Right, okay, so I was thinking that we would take these one by one and actually make rulings on them, but we'll digest them one by one and then make rulings at the end. So let me say this, we'll have two opportunities for public to speak. Would anyone like to speak now? We're all set with our voluminous public. Thank you, yes.
Ms. Parker, one thing I would suggest is just as far as drafting these findings and making sure that everything's neat and tidy. To your point of taking sort of a vote on each and every one, I think that that's absolutely appropriate. What I would say, just because of the statutory requirement that a written finding be issued within 7 days, what my suggestion would be, and of course I look to the counsel for the parties to see if they would agree with this. I think it's what maybe we have done in the past, is that you can take a vote on each and every one of the various grounds, but that we leave the final vote as to whether to grant or deny the appeal until a meeting to be determined, so that you can actually review the proposed findings, make sure they're consistent with what you have decided, then sign it, and then we have 7 days to provide that decision. And also, at least from my perspective, from a appeal standpoint, the clock does not start running until a final vote has been taken. And so I think from my perspective, that's the most appropriate procedure, but I'd invite comments from council.
Well, it's consistent with what we've done in the past, so that's a good reminder. Anybody have any questions or comments about that? All right, point the one. So we are going to go back to the document that starts there, 1 through 8, is that right? So I'm sorry, so that I'm not lost. I'm hearing some sound from somewhere. We're going to now go over each of the 8 points that are in the thing, okay. And Attorney Rachin, is there more substantive things that you're gonna add, or is this just discussion?
I don't think so. I think, my task, I think, was just to talk about the remand orders, how they inform the analysis here, talk about the standard of review. We did an overview of each and every ground of appeal, and now I think it's showtime
Okay,
to discuss the substance of those grounds.
very good. So the first part, the planning board should not have held a site visit nor received or considered new evidence related to the scenic view of, or architectural harmony. What say the board, and what say, that really seems to me like two different issues, whether a site visit is in and of itself new evidence.
Mr. Chairman, I
Yep.
think what might be helpful before the board starts talking about it or deliberating it, perhaps that.
Oh, I'm
if
sorry.
If council is inclined to make submissions, they may or may not be, but.
Thank you for keeping me on track. So, Bruce, if we can go back to the screen there. So we have Mr. Doucette and Mr. I'm sorry, Murphy, right? Yeah, and you are muted, by the way.
I'm happy to go first this time.
Why don't you go first? Well,
I'll be brief. I have also submitted written submissions dated May 6th, but to the extent that the council here hasn't had a chance to review them, in regards to the first issue, I don't think it's two separate issues. I think essentially what Attorney Collins is arguing is that the planning board shouldn't have considered any new evidence, and so a site walk at a later date would be considered new evidence. That being said, that as part of the record, that was old evidence and was a previous site walk, and they certainly made reference to that, and they were allowed to rely on that previous site walk as well. And I think the planning board took great pains bifurcating the two issues. I think their findings of facts and conclusions of law were well done and spoke sufficiently with respects to the prior record and only that evidence before them on the prior record. And so to suggest that the planning board lacked somehow the capacity mentally in their mind to separate those two issues, I think is somewhat insulting. But regardless of that fact, they did just that, and they did so appropriately. It was only after they made their initial decision that they said, in the event that the court's order invited them to take on new information, and I think there's been discussion today that the court order wasn't really clear in that regard, they did that as a belt and suspenders approach.
and Mr. Murphy, do you want to add anything?
Yes, I think that Ms. Collins took issue with the planning board taking a site walk, and I think it's important to draw a distinction between the site walk that occurred before the meeting in 2022 and the November 21, 2019 first site walk. And there's actually a reference in the planning board's decision to the first site walk, which is to say that the planning board took a first site walk in November 2019. At that time, they observed the site and also took in the surroundings, which include balconies. So there are references to balconies. There's one balcony across the street at 23 Central. There are other balconies. I think there's a balcony on the building that you're in right now. But a lot of these balconies are visible. And so I agree with Andre that the decision's bifurcated in a very careful way. And I believe that the decision can be upheld based on the existing record as described by the planning board. And then with respect to additional evidence, the planning board addressed it because both parties submitted new evidence to the planning board and then considered it in a very careful way so as to sort of sequester it.
Thank you. Discussion among the board.
I have a few comments.
Yep.
In addition to what comments that council made, I think it's worthwhile noting that neither the site visit nor the scenic views were part of the remand from the Superior Court, so therefore they're not properly before us. Secondly, there's no restriction in the order of the Superior Court to a site visit. Number three, sections 1302 and 1304 of the Land Use Ordinance specifically allow the planning board to make site visits. So it's beyond me why this is a problem.
Yeah, I think that the planning board appropriately bifurcated its decision. And I think that we have to give them credit that when they made their original decision with not considering new evidence, that they can do that. They can actually do that. And I think that we have to give them credit that they can do that. And so I don't have a problem I have a problem with this. I think you can have new evidence, but you also can make decisions while putting that new evidence aside.
Anybody else?
I would agree. We've been asked to do similar things on this board. We seem to be able to handle it. Yeah, I think them making, such a statement to bifurcate, my new word of the week.
It's getting a workout.
Proves that they made the effort. I don't know. I agree with my other board members.
Terry?
I agree with my other board members. I have nothing to add.
I know that one of the important roles we have here is to not make the appearance of rushing through any of this stuff. And I think that the important thing for everyone to realize is that we've spent hours and hours and hours reading over all this stuff and watching the video when we have an opportunity. So our conclusions that we come to here are backed up by lots of observation and reading of what the planning board did do. I know that in past versions of this kind of thing, we were reminded to cite, if you will, various efforts that the planning board made and everything. How do we stand on that, Leah? And you're muted. There we go.
Yes, I appreciate that question. I actually am a detailed-oriented person, and so I do think that it would be helpful in your findings to, cite to, if not the record, if you note that the planning board's decision, the post-remand decision, I think this is trying to get the date here, the February 7th decision does reference various record citations. So if there were ones that you found particularly compelling or persuasive, you could note that. Alternatively, I think you could say that, the evidence cited in the evidence specifically cited in the post-remand decision is sufficient record evidence to support their decision. I like more details, but I do think that if you determine that the evidence cited in that decision, it constitutes substantial record evidence, I think that would suffice. I leave it to you.
Well, I would opine that between the findings of facts and the minutes and the video and everything that we've reviewed, that I appreciate Leah's observation that it would be permissible to refer to that in the aggregate.
I would say if there's anything that you specifically don't agree with, that you wanna make that clear. You know, I think you wanna show that you are exercising independent judgment and that you are not simply wholesale adopting the planning board's decision. But of course, your task, as I said, is to make sure that the planning board's decision is supported by sufficient record evidence. And so I think it does make sense to specifically look at their decision and to note which evidence on which they rely that you're finding to be substantial record evidence. So I would encourage you to do that.
Leah, excuse me. Both of the issues in this item of appeal are not properly before us. So what type of an order?
Say it again?
I'm sorry, I'm not sure which issues you're talking about, just so we're all on the same page.
I'm talking about the site visit and the scenic views in
I
item one.
I think that, I'll weigh in on that, I appreciate that. They're not within the scope of the remand order. It's not specifically stated, but I think the question of whether or not it was appropriate to take additional evidence is something that should be at least addressed by this board, because I think there is confusion around whether or not the remand order allows for it. So I think that that is an issue that we should address. I do think that it's not particularly onerous because, as the parties have talked about, it's very much bifurcated. So I think you can say, look, if this is the case, I'm not trying to lead the witness here, but if you find that the record supports the, the conclusion, then you can say that. You can also say that, in addition, the additional evidence, what do we call it? The supplemental evidence also supports that. But I think, as did the planning board, you want to essentially bifurcate your own decision about whether or not A, there's substantial record evidence to support the conclusions based on the pre-existing record, and you then want to say, and oh, by the way, we think the supplementary evidence also supports it, or not. I think you want to weigh in on that.
Mr. Chairman, I have a proposed order.
Yeah.
Okay. The proposed order is as follows. In order to comply with the orders of the court concerning additional information to support planning board findings, the site visits performed by the planning board were not an error of law or an abuse of discretion, and its findings were supported by substantial evidence.
Okay, then you're putting that in a form of a motion.
I am.
Do we have a second? Okay, a discussion on the motion?
I might add, if you think it's value added, it may not be. I found them to be consistent with the requirements of both the land use ordinance section 1300 as regards site plan review, but more importantly, the authority that they have both as to limits and discretion meets the requirements of section 1003. Is that how we usually say it? Architectural review standards. Is that helpful or unnecessary?
I accept that as a friendly amendment.
Well, amendment or otherwise, it into the record, it shows specific evidence.
That's
So
what I was
that's-
thinking,
Yeah, so that's, I think that's.
And
an
it's real, I
appropriate
really
comment.
did reconcile those.
As well, 1302 and 1304 specifically allow the planning board to make site plan visits.
Yep.
And exercise the discretion that they did.
And I want to make sure that that your motion is referring to pre-remand timeframe, and then we'll go ahead.
Yeah, I think that, Mr. Chairman, I take your point. So I heard the motion talks about how the site visits were not an error of law or abuse of discretion. I think that and that's a perfectly legitimate motion, and I think that's great for you to weigh in on. but I also think, and it may have been coming, and I'm you know, I think it's also important to say, even if the evidence, you want to talk about the pre-remand evidence as well. I think it's important to weigh in on both of those things.
And
You know,
to
I-
do so separately.
Yes. Mr. Chairman, I see a question from council.
Oh, I'm sorry. Thank you. Feel free to put your hand right on your camera and shake it a lot. Go ahead. Yeah, Mr. Murphy.
Thank you. No, I just wanted to remind the body here that there was more than one site walk. So there was one pre-remand on November 19, 2019. That's relied on by the planning board at paragraph 7. There's a reference to the first site walk. So that site walk is part of what the body considered, the planning board considered. And then there was a subsequent site walk that occurred more recently. And so when we talk about part 1 and part 2 of the decisions, part 1 may consider that site walk in 2019. That's not a problem whatsoever. And then part 2 doesn't, I don't think it references the site walk of that day, but a site walk occurred that day. So when we talk about the site walk, consideration of the site walk, visually observing balconies across the street, so on, that ties to the first site walk of November 2019. I just want to make sure that's clear for everyone. And that's on paragraph 7 of the planning board decision under C.
May I also add, because I don't want to confuse the issues, because there's talk about architectural review and scenic harmony. The question, right, because we're taking all of these questions separately, the question right now is strictly, did the planning board improperly consider new evidence as to architectural harmony? So it's whether or not the new evidence submitted was, did they improperly consider it? And the planning board bifurcated the two issues. So I think the only question before the board right now is, did they, yes or no, did they improperly consider it? Leave you to make that decision.
Well, yeah, and I think that a two-stage vote will clarify that.
I think it's a good hook that we had site visits both before and after the Superior Court's most recent rulings. And that could be the hook to
Yeah,
before
let's
and
make
after.
it even, let's be even more anal in terms of a and we may have to retract the motion, because I'm a visual guy, and then the first two lines were kind of poking the bear there for a minute. But let's make sure that the way that you've worded that allows this vote to be pre-remand, and then the next discussion and vote would be post.
Okay.
So if you could just read back your motion, and so we can clarify that.
Okay, my original motion is as follows. In order to comply with the orders of the court concerning additional information to support planning board findings, the site visits performed by the planning board were not an error of law or an abuse of discretion, and his findings were supported by substantial evidence. And as I've said, I've heard a number of friendly amendments here tonight.
Yeah. So, normally for an amendment, just to clarify that, someone would propose an amendment, second that, we'd vote on the amendment, and then we'd vote on the whole motion. Anybody want to offer an amendment that clarifies our time frame?
I move that we add references to it being consistent with the provisions and requirement of the land use ordinance sections 1300, site plan review, and 1000 architectural standards. Is that, yeah. Is that what you're looking for?
Well, we can add that as a.
Then, and then add the moniker pre-remand, and then to go through the same thing again.
That's what I was looking for,
Post-remand.
yeah, but.
Yeah, so I would add,
Do you want that to be in one motion or two? Are you saying?
they're asking for two motions. That we
No,
do-
I understand two, but in terms of your modifying
Oh,
is.
yes, I think it applies to both, because I looked at it through both lenses as well, bifurcated lens.
So, the bones, yeah, Leah.
Yeah, I absolutely appreciate all of this discussion, and I understand I think I understand what the board's, getting at. But I think that I'm gonna try to simplify things, right?
Okay.
That with respect to the first question, the ground of appeal is the planning board should not have held a site visit and should not have received or considered new evidence relating to the scenic views or architectural, harmony. I think when the assertion is the planning board should not have held a site visit, I think it's implied that it's post-remand.
Okay,
So,
of course.
just because I think there's no possible argument that the planning board could not pre-remand hold it, I mean, it's axiomatic that they can. So I think what I would suggest is, not that the discussion and all of the, motions and amendments aren't excellent, but I think just to simplify it, I would suggest withdrawing the motion and just simply make a motion about whether or not the site visit, the post-remand site visit was appropriate. And then we'll do the
And why,
motion
yeah.
about receiving or considering new evidence.
All right, well, if we're talking about the post-remand, aren't we talking about new evidence?
Yes, it's all new evidence, but I think what I would say is and I think what I heard said at the outset from the board was there are two questions here. One, was it okay to do a site visit post-remand? And two, was it okay to accept new evidence post-remand? In essence, they're I think kind of the same thing, but just to cover bases, I think you want to have those two motions.
Okay.
Okay.
Would the motion maker in the second agree to pulling back your?
Oh, I retract, yeah.
I do as well.
All right.
I could suggest amendment to my original language.
Well, if you were to cut it in half and simplify it, and yes, we await your sagacious words.
Okay, let me try this and see if this fits. In order to comply with the orders of the court concerning additional information to support planning board findings, the site visit performed by the planning board after the remand was not an error of law or an abuse of discretion, and its findings were supported by substantial evidence.
Do I hear a second?
Second.
Okay. So it's clear that we're talking about pre-remand. It's, I just was looking for something even more simple.
Post-remand.
Post-remand, sorry.
Sorry.
Okay. Any discussion on the motion?
I'm basing mine also from, I agree with many parties who have said, and particularly Murphy, that there's nothing in the ordinance, regardless of what the judge's order was, that the planning board has the authority to do what they did by the ordinance, and I just think it's moot.
There's nothing preventing them from.
Right,
Right.
right.
All right. Calling a vote on this motion. Max?
Okay, so, yes, in the affirmative.
Terry?
Yes.
Yes.
Aye.
Yes as well. So, now, excuse me, get that back up. All right, so do we need anything, Leah, on,
Yeah, I think, again, maybe it's, belt and suspenders, but the motion really was with respect to the site visit, and so I think you wanna have another, motion about whether or not they should have received or considered new evidence relating to scenic views or architectural harmony.
right? Somebody want to make that motion?
Oh, I see a hand, Mr. Chairman, I
Oh,
see it.
I'm sorry, thank you for reminding me to look over there. Yes, sir. Mr. Murphy.
Thank you. I just hope to have clarification about the site visit that we're talking about, because there was one in 2019 that's part of the record, and then there's the site visit that occurred in 2012, I believe. So I assume we're 2012, and that was only considered for part 2 of the opinion, not part 1. But if we can have clarity about which site visit we're talking about, that's helpful.
I think I heard, Mr. Hall say it was post remand, but I could be wrong there.
You're correct.
Okay. Thank you.
All right, so now dealing with scenic views and architectural harmony.
Except we're not
And he
dealing
said
with
that-
scenic views. I thought that was
Well,
off the
we-
table.
You said new evidence, considering new evidence.
Thank you. Thank you. Yeah, we've taken that off the table previously. Any motions of the two-sentence variety?
I'm a little unclear as to exactly what we're trying to develop a motion on.
Yeah, I think what I want to hear is some discussion about whether or not, again, whether or not this argument that the planning board should not have received or considered new evidence relating to, scenic views or architectural harmony. Whether or I mean, maybe it could be as simple as just should not have received new evidence post remand. I think that's truly what the issue is that she's getting at. When I say she, I'm saying Attorney Collins is just alleging that post remand there should not have been taking new evidence.
Yeah,
And so I think that's
it's the second part of that sentence.
Well, in the order that I propose, it says, in order to comply with the orders of the court concerning additional information. I mean, what more is there to say?
okay. I thought your motion was with respect to site plan,
Site visit.
a site walk. I'm sorry, site visit.
Yes, that's what this issue is about.
But it's not just the site visit. There was, in addition to the site visit, in the photographs that are in the record that were taken at that second post-remand site visit, the parties, both parties, submitted additional documentary evidence in the form of expert architectural commentary. I think Mr. Priestley submitted additional evidence with respect to what a possible redrafting of the design would look like. So I do see them as conceptually distinct. I think site visit, the new post-remand site visit is one thing, and then the additional documentary evidence that was submitted. And I think they're separate. And she says planning board should not have held site visits and should not have received or considered new evidence. I see those as two things.
And may I offer one more thing, just in terms of your discussion purposes? I think it's clear to, our argument is that the planning board did not consider new evidence in their decision one. They
Right.
appropriately
Right.
bifurcated
Because
it,
they
and they had every right to do that. And so I don't want to confuse the issue, because I think Attorney Collins' argument is that they considered it, and there was no way in their minds that they would be able to appropriately ignore the evidence submitted by the parties. They were just-
Tainted
they were
minds.
Totally incapable of doing that. They lacked the capacity.
Right, and so, I mean, the way I envision this analysis is, was it appropriate to do this additional post-remand site visit and evidence? You can answer that, but the next bit of that analysis is then to say whether or not it was appropriate. They already made a decision based on the pre-remand evidence. And so again, I know we've been throwing this word bifurcate over and over again, but I think that as did the planning board, your decision should similarly be bifurcated. Meaning, substantial evidence, and again, I'm not telling you what your decision is, I'm just thinking, if you decide that there was substantial evidence to support the conclusion based on the pre-remand record, you want to say so. And then you want to say, and we find that it was or wasn't appropriate to have additional evidence submitted, and we think that also supports or doesn't support. But I think that you want to absolutely clarify whether you believe, A, there was substantial record evidence to support the decision based on the pre-remand record, and then you also want to address the issue around additional evidence. But what you're being asked here was whether or not they should have conducted a site visit and whether or not they should have considered new evidence. So you make that determination, and then you can say, if it is in fact your belief, that in any event, decision one, was based on the pre-remand record, and you find that if you do, there was substantial record evidence to support that.
Roger.
I'd just like one more bit of discussion, just for clarification, before I could even form
Okay.
because it seems to me, unless I read the two court orders wrongly, it seemed to me that, first of all, we've already agreed that they had the authority to do a site visit, but in regards to even looking at new evidence, wasn't the judge asking them to go back and not only just, now that the balconies have been changed and are being constructed, weren't they supposed to go back and look at those? I mean, the architectural harmony, I think, also was just limited to the balcony issue, right? The front balcony issue. So that was
I agree with
generally the purpose of that site review. Again, I'm now in the new evidence kind of thing. And they could do both. They could be looking at it with two different eyes, okay, pre-remand and the other site walks, and then to look at it again and saying, and now we are looking at it anew. We are considering this is a new, fresh sidewalk. Stuff's been built. We're looking at it. The judge seems to want us to do this. And we're coming up in this post-remand. We are considering new evidence or fresh or de novo, and we're still coming up with the same conclusion, no?
Well,
Because the judge
no,
seems
we're
to be
reviewing.
asking them.
We're reviewing. We're not de novo on this. But
Right, no, them, that the judge,
oh,
that it was proper for them to go and do both things in both directions, because it seems like the order, the judge wants them to review that balcony issue, and it seems like the architectural harmony issue is solely related to that. So what are they gonna do but go look at a site walk? Am I confusing things?
no, you're. I think you're going and saying, look, the zoning board is allowed to do this, but the very specific
No, the
question.
planning board's allowed to do
I'm
it.
sorry, yeah. Which are we on?
It's okay.
The very specific question is, the Friends of Rockport say that the planning board should not have received or considered new evidence as related to scenic views and architectural harmony. Just take that statement and say whether they should have or shouldn't have.
No, scenic is
what we're
off,
looking for.
scenic is off the table. We
Scenic is
shouldn't
off the
even-
table, but
we
it's
shouldn't
off the
even have it
table
in
for
there.
us in terms of its,
I think you
We-
can shorten it by
Yeah.
just saying new evidence.
New evidence,
whether
yeah.
regardless of what it's relating to.
I think the fact that we took it off the table is different than, we're just using her phraseology.
Thank you.
But
Yeah.
new evidence
And-
works.
And if I could just speak to this notion of whether the court is inviting there to be new evidence submitted. I think the reason why, the very reason why, that the planning board bifurcated its decision is because I think that order could be interpreted in either way.
Thank you,
Right.
Clear, yeah.
thank
Yeah.
you.
And
Yep.
so I hear what you're saying, there does seem to be some invitation to do that, and yet, the
Yeah.
default is that you don't unless they specifically say, hey, board, consider this, I want you to do so. So that's why they bifurcated it.
Okay,
And they're covering their bases. And I think that this board needs to do the very same thing.
Right.
Mr. Chairman, I have some language.
Thank you.
Okay.
Let's hear it.
This would be after the language I proposed previously, so it would be a second sentence. The evidence developed, supplemented, and confirmed the prior findings of the planning board, which were based on substantial evidence, were not an error of law or an abuse of discretion. So it confirms the prior findings, but authorizes, it also affirms that they had the right to do an additional site visit.
Do I hear a second, or do I hear a rewrite?
Do you want me to try reading it again? Okay.
Can I try?
I can try.
Yeah, if someone would just, I think that the board, not just me, but the board would be more comfortable with a shorter, sort of, you know, using the phraseology she has, new evidence. Doctor?
Now, this is a little bit cumbersome here, so.
Oh, why not?
So I have, and I have to apologize to Leah, because I can't, I was focused on what I was writing, and I wasn't listening to what you're saying, and I can't bifurcate my focus. See what I did there? It's one of those.
Masterful.
I move that it is understood that new evidence related to architectural harmony post-remand was provided to the planning board. It is also felt appropriate this was considered as the planning board's post-remand decision was bifurcated. A decision first made without considering new evidence and subsequently considering that evidence. See, there, it's just not.
So
So we
you,
can
you
clean
ha-
it up.
you haven't, in that, I'm sorry, any seconds on the motion discussion thereafter?
Which one, the second one?
His motion, yeah.
It's be cleaned up.
You want to clean it up some?
Yeah, I can't. I just-
Oh, you can't. Can you don't read your handwriting? Let me just point out, and I have no more, certainly less than some of the people on this thing, experience in this, but I'm wondering whether your wording addresses whether the board feels that additional information was appropriate.
Said it is felt appropriate, this was considered.
Okay, so I may have missed that.
You can read it.
So, I move that it is understood that the new evidence related to architectural harmony post-remand was provided to the planning board. New evidence was provided. It is felt appropriate that this was
Considered
considered as the planning board's post-remand decision
was bifurcated.
was bifurcated, a decision first made without considering the new evidence and subsequently
Yep. Considering.
considering that evidence. So you've hit both sides of it.
I think, but it's not the smoothest.
Leah, if these guys take a vote on substance, would you be able to help them with some phrasing?
Yes, I think I would be more than happy to do that.
Thank you.
Give me 1 second, I'm just typing something and I wanna make sure that it's okay. Can you give me 1 sec?
Sure, please, thank you.
One suggested change to Kevin's language, and that is, instead of felt, say believed.
Yeah,
Or how about fines?
get to the point.
Fines.
Is this mine?
No, it's mine.
There's no faith, hope, feelings, or belief on the board.
Nobody gives a shit how you feel. That's what you can argue.
Who thought wordsmithing would be this hard?
It's hard.
May I also make another comment about the wording?
Yes, please. Leah's still working on her thing, go ahead.
And I'm wondering if we shouldn't just add a brief thing at the end and that it's consistent with the judgments contained in the first order in judgment of December 2021 and the further order in judgment of January 22, which indicates that, this should be remanded to the planning board for reconsider, oh no, that's parking. Excuse me. But that we should make a site referencing those two orders, that we're looking at it from what our land use ordinance requires, but we're also finding that not inconsistent with what the judge has asked and ordered. Or is that not important?
Well, I think what Ms. Collins was, actually, put that on hold.
Okay.
Leah, you have a suggestion for us.
Yeah, I mean, I think this may get to the root of it, and this is something, I would just suggest this. We find that it was appropriate for the planning board to conduct a post-remand site walk and to consider additional post-remand evidence. However, we also find that the pre-remand record constitutes substantial record evidence to support the planning board's finding.
Beauty.
Second.
Well,
No, I know, somebody has to make it.
Where are we in terms of you coming up with wording and us adopting it as a motion? There's no issues with Robert's Rules of Order or anything on that?
Well, I don't think so. I think basically I completely and utterly defer to your judgment. I am simply just formulating these things based on the discussion that I've heard. I would never suggest a motion unless and until I heard conversation
Right.
and discussion.
And if you did so, we might vote against it. So
Indeed, that's happened.
Leah's just synthesizing the discussion we've had here.
Yeah. So I find that to be a more digestible motion. Anybody, oh, you have seconded it. We're in the discussion phase, which I just started. Any other discussion?
And one thing, you know what I might suggest in order for this to be more streamlined is that, I have, as you know, Ben Plant, my colleague, is out there and he is taking notes and he is, I'm assuming, you know what they say about assuming, but that this board would like us to take the laboring oar in drafting the findings that will come back to you, then will be, reviewed
Yes,
and
please.
approved. Yes, okay. So what might be better is for us to go through each and every round of appeals, for us to hear your conversations and what we believe to be your ultimate conclusions, and that we will come up with a draft findings that you can go through and make sure that they are consistent with your deliberations, and then you can take a vote on them then, and you don't have to necessarily do motions, etc. We can go through each and every one. As I say, we'll figure out, based on the deliberations, what we think your synthesis, and we'll synthesize that, at which point next time you can review and make sure that they are consistent, and then you can do a final vote on them next time.
Because we would roll that, it wouldn't add any amount of time onto it. We would be doing that at the same meeting where we had discussed before the whole idea of the findings of fact and signing that.
Absolutely.
Yeah,
Absolutely.
so we're not
Yeah.
adding any time, we're adding clarity.
I think so.
Honestly, I think this might help. I'm noticing a pretty serious discrepancy between the administrative appeal filed, or sent over on March 7th, and I don't know whether she's allowed to do, I'm not about allowed, but which one should we consider? Because on April 11th, she restates Article number 1, very much more simply. Ugh, horrible sentence. Planning board improperly considered new evidence as to architectural harmony. She doesn't say anything about site walk. She doesn't say anything about scenic view, which that's fine because that's out of there. And then she further says that I therefore ask the board refer to this letter as the basis for the appellant's arguments. So won't that make our job easier if we simply
Follow along.
follow that one single sentence? The planning board improperly considered new evidence as to architectural harmony. And we don't even have to worry about site walk and all that stuff.
Yeah, I will say, I don't think they're entirely inconsistent. I think the
Right.
site walk is what
Is
happened at the site walk, what was
inherent
seen
in
at the site walk
Right.
is in essence new evidence. So,
But isn't this a more a simpler sentence from which to form the basis of a motion?
well, I think it's important to
decision.
understand that these sentences are not the entire basis. It's just a heading. And if you read the next sentence, it says that the planning board was tainted because it held a site walk on the morning of.
Okay,
So
fair enough.
I think the concepts are fairly consistent.
Okay.
So, Bob, did you have something you were gonna jump in with?
No, I think I like the synthesis that Leah's come up with, and I look forward to seeing it drafted.
Okay. So is everybody comfortable with having substantive discussion and then leaving it in the capable hands of our council?
And that's in lieu of making a motion for every one of these.
That's in lieu
Yeah.
of three more
And-
hours.
Phenomenal. Let's do it.
I might
And
be,
I will say, Mr. Chairman and members of the board, I know that that has been your process, and so I certainly do not want to interpose myself or make your process different than it is otherwise. But let me be clear, what I would provide and what Ben and I would provide would be a draft only. you would, not only would you, but you are required by law to review them carefully, to impose your own
Okay.
personal, you know, to exercise your independent judgment when you're reviewing them. They're simply a draft, and you tinker with them, get out your red pen, and, you know, it's your decision.
Okay.
Mr. Chair, I may have some motions to propose, but
Sure.
that can be informative to Leah and her colleague in terms of how they ultimately
No.
draft it up.
So let's make sure that you have an opportunity either at the end or in the middle of it. It may be that your observations are significantly clear enough that they'll be incorporated
Yeah,
in anyway.
and I'll do it with respect to each point of appeal.
Sure, all right.
Okay, cool.
Very good. So,
All right.
I think that we have, that Leah and Ben have a feel for how we feel in this one. So
Okay.
we're gonna move
So
on.
then,
Go ahead, sorry.
so, I'm in your hands. You want to move on to the next one?
Yes. Number 2, planning board erred in determining that the 2012 approval for Union Hall did not rely on the 25 spaces being added to Sandy's Way by the developer to serve that proposed use. See Lucadia application and minutes of June, July, and August 2012, planning board meetings included in planning board record. So, discussion on, we won't have a motion, but discussion on whether the planning board erred in determining the parking now, the 25 spaces.
One point that I think is interesting that the Superior Court raised was,
I'm sorry, we would, at this point, it would be an opportunity for them to.
I'm sorry, go ahead.
No, that's my mistake entirely.
Certainly. Well, this is kind of brief. I mean, the question before the board and before the planning board and essentially now the ZBA and affirming the planning board decision is, what did waiver mean? And the court specifically asked whether the waiver was complete such that there was no spaces in Sandy Ways dedicated to Union Hall, and all those spaces were available to 20 Central's patrons. This is exactly what the planning board did on remand and determined that the planning board, in 2012, waived the parking requirements down to 0 spaces. And when it did so, it intended to do exactly that. And I'll quote exactly from that meeting. It said, after considering the parking, the then board chair, Mr. Leichman, noted that waiving the parking requirements would be the smartest thing to do. And then the board voted 5-0 to waive the parking space regulations for this project. There's no other way to interpret the meaning of waiver in this context, especially considering that neither party at the time in 2008 or in 2012 had legal rights to the Sandy Way parking spots. So therefore, the spaces were never assigned to another use or subscribed in that context.
Thank you, Mr. Murphy. You want to add anything?
Just simply that, at paragraph 10 of the planning board's findings of fact, there's an excellent discussion of how, waiver means being excused from the legal requirements. Waiver doesn't mean dedicating spaces. And I think that, as Andre noted, that the party at issue didn't even have the legal right to promise those spaces in any event. So there's also additional discussion about Sandy's Way lot being expanded after 2012 as well. So I think that the planning board decision is very sound and well-reasoned.
All right, thank you. Going to Bob first.
I just want to make a point. At the bottom of page 9 of the court's, Superior Court's December 1 ruling, the court said, factual findings must be reviewed with deference, and the court may not substitute its own judgment for that of the applicable local board. I think deference is extremely important. That means that the court has to defer to the considered judgment of the local board. They just found in this case there wasn't enough considered judgment. There needed to be more evidence in the record. And in fact, the planning board at great length and in great detail went through the evidence concerning the parking situation in Sandy's Way. And I think that now there is substantial evidence, and the court should defer to it, and we should affirm the findings of the planning board, both prior to the remand and afterwards.
Okay.
I think when you look at the minutes of the planning board meeting.
Yeah.
What you see on page 4 and 5 is a really extensive effort to try to figure this out. And as council has already said, they've gone through this and they've done the best they can in defining waiver. And it seems like their reasoning was sound, and I can't see any other way that they would get a more precise answer after reading this.
I agree, and obviously it was a different downtown in 2012 than it was during other time periods subsequent. And I think the most compelling thing is it's really evident that, as has been stated, the Sandy's Way parking simply was not considered because it wasn't theirs to consider. It's privately owned parking. It's not anything the planning board could have swiped a paw at, even if it wanted to. I think people have gotten confused, as also has been noted variously by both sides, that just because the public at some point swarmed in and kind of used it, it's not even relevant. But in 2012, Sandy's Way was not on the table, it was not considered, and that was proper, and the planning board had the authority under the ordinances as they existed at that time to make that kind of waiver, and it made sense at the time. So, to me, that's, yeah, I agree. That they did not err. Is that the correct answer?
Yeah, and I think I'll also point out that Kerry Leishman, who was, the chair of that board, had been the chair for many years. There's no doubt in my mind, both reading the minutes and the findings of facts and everything, but as I don't want to say habit in the laissez-faire mode, but as something that they did all the time, the planning board knew exactly what waiver meant. It means it's off the table, and they had done it several times prior in the downtown area. And so it's important for us to know that how we got to where we are is not just one waiver decision, it was a whole series. So I think that the planning board knew what they were saying, and I think we know what they're saying, and I think that it's held up by the evidence in front of us.
Yep.
Leah, would you like any sort of straw vote, or do you just want to read the body's language?
Nope, I think, I don't think we need to do that. I think that, as I said, I think the most efficient way is for me to glean let me put it this way. If, in subsequent grounds here that there's more dispute or debate or disagreement, then I might ask for that. But here, I think at this point so far, if not consensus, people have similar views on that. So I don't need that at this point.
Leah, let me offer you some language for your consideration as a proposed motion. The Zoning Board of Appeals finds that the Planning Board had substantial evidence supporting its findings both before and after the remand that 25 parking spaces were available for allocation in Sandy's Way, and that there was no error of law or abuse of discretion in doing so.
Tasty and bite-sized. All right.
Can I just make one correction, possible correction? 25 spaces is what was discussed with respect to Union Hall, but I think it may be perhaps 28 in
the final.
If you'll give us the authority to actually look and see what that requirement was, I think it may have been 28 spaces, but,
28 spaces, paragraph 10.
Okay.
pardon?
I think it's 28 spaces, says in paragraph 10 here,
Okay.
for the findings of fact.
Are you okay with that little
I,
revision?
I am. That's probably a typo on my part, so I'm
Well,
sure
the
that.
reference is 25 in the
In the complaint, yeah.
appeal here.
Okay.
Well, that was 25 spaces back then being added to Sandy's Way.
Right.
Exactly, I think the
It's-
calculation
What year are
was
we in?
that the.
Yeah, it's not about the 28 now, just saying that
10 years later.
they didn't air and not
been a
take into
decade.
consideration because that was private parking space that they naturally could not and would not consider in their final deliberation.
All right.
And through the lens of an appellant review, we're only considering whether they considered all the evidence and came to it reasonably, right? I mean, that,
At that
no, I
time,
keep trying to compartmentalize all these.
and according to the ordinances, under the conditions at that 2012, and under what the provisions of the ordinances were, which were different than they are today.
All right, we're all settled on complaint 2, going to the item number 3.
So I'm sorry, are these motions that are suggested, just, we'll review them through the findings of fact later?
Yes,
Yep.
if
Okay.
we have any issue with the way that they're written up.
We're not proposing motions right now, but
No.
we will at the end.
No, we're trying to get out before midnight. Number 3, the planning board erred in failing to apply the shared parking standards applicable to the hotel and to consider the competing demands on the Sandy's Way lot as required by the land use ordinance and the Superior Court's order. All right. Parties of knowledge and import.
I really don't have much to add here because you only get into shared parking if you had previously found that there wasn't enough spaces to be allocated to the project. In fact, there was never a request for shared parking. The only request that was made was for off-site parking. So I don't even think we get here.
Right.
Mr. Murphy, anything to add? Or,
Yeah, the Sandy's Way is under common ownership now, so it's not a shared lot under the LUO, and that's reflected in the planning board decision at paragraph 13, is discussion of that. So when you think of shared as a term of art under the LUO, this project doesn't qualify. And then beyond that, there are additional arguments using the lay term shared, that there are other folks who are using the lot during the day, getting a cup of coffee, going to the post office and whatnot. And the planning board addressed that and essentially stated that this is a private lot and that it's not shared with the public in the lay sense, and that the planning board expects that the hotel will monitor its own lot, once approvals are in place. So this idea that somehow there's a burden on the lot because it's shared with the public, you can't base policy based on trespassers. They don't have a right to be there.
all right. Board discussion.
Well, the Superior Court didn't make any specific findings about shared parking. They just asked the planning board to consider it and make factual findings with respect thereto.
Right.
And that's what the planning board did.
And they met their threshold of completeness.
Yes.
Anybody want to add to the verbalization of your body language?
Yeah, I guess the importance is how you define shared, whether it's a common term or it's used in this term. They also mention, and I'm not sure exactly what this means and if it's important, because I haven't read the whole parking 803 section, but basically it said, in shared parking, the applicant shall provide evidence of a lease or other agreement establishing the shared parking, and there's no evidence that that is the case in that parking lot either, if I'm reading that correctly. So, again, I think, to me, this is shared in the common sense, not shared in the land use ordinance sense. And it's not an issue.
Yeah, Mr. Chairman, if I could weigh in on that, I think that, I absolutely agree that the land use ordinance with respect to sharing parking is clear. I think, what is less clear is what the court meant by it. And actually, I think the court did actually talk about sharing the burdens with the public in the various buildings, but I think, Attorney Murphy addressed that issue with respect to the extent the court believed or directed the planning board to consider shared parking with other businesses and general public, I think that Attorney Murphy at least addressed that from the town's perspective. I don't know if the developer has anything to say on that, other than what was already said.
Nothing to add. We think the planning board appropriately considered it and made a decision based on their considerations post-remand.
Terry?
And they didn't err in failing to apply because the shared parking standards and consideration of competing demands on the Sandys Way lot would not be required in this instance.
I just want to take a quick look at the April 11th letter from counsel who's not here.
Same wording.
Yeah, yeah. It's a positioning. All right, any other discussion from the board? It appears as though the board is a 5-0 on this.
Yeah.
Okay. 5-0 meaning that they didn't err.
Right. And that there weren't competing demands because you have specifically allocated spaces for specific two different businesses and the hotel and the satellite, and it's all very clear. There's no competition. You're saying there's this many available for the hotel and restaurant, there's this many available, and there's this many on the, so the whole shared language is, to me, moot. That's why they didn't err.
All right.
It's not competition, and it's not shared.
So moving on to number 4, the planning board was required by the court's order and the land use ordinance to review a parking and traffic study in conjunction with its consideration of parking on remand by the Superior Court. And its conclusion that the parking requirements are met without considering the parking and traffic study is not valid. Council, how about Mr. Murphy first, since Mr. Doucette's looking stuff up?
We talked about the traffic study earlier today, and this argument from plaintiffs is conflating the two actions. You've got the ADB action, which is addressed in the site plan review, which is before this body. And then you have the CV action, which says you have to apply petition A and petition B to any building permit that's addressed by the CEO. And in that CV action, the old building permit was actually revoked. It was vacated. Whereas the site plan approval, the decision was not vacated. It was just remanded for these issues that we're addressing here on appeal. So if you look at the letter from Ms. Collins, she's using the court's direction to consider overlapping burdens between the public and the hotel with respect to the hotel's parking as sort of a mandate to look at a traffic study. I don't believe that you can read the court's opinion that broadly, that the mere reference to overlapping burdens allows you to import a traffic study. And if you actually look at the decision of the Superior Court, it is commanding the CEO to consider the traffic study in relation to any new building permit. But that's not really something before the planning board. So it was not error for the planning board to decline to consider a traffic study, before or even closer to this date.
And I would only add further that when you look at the actual language in the court's order, it seems to suggest that the planning board may consider it if it happens to have that information before it, but it certainly didn't need to. And then again, and this is what was unfortunately left out of the court's orders, when it's cited to the actual language in the zoning ordinance, the new petition A language relative to section 803, it left out CEO. And so the planning board in this particular instance did not commit clear error by saying we don't need to take into consideration because the CEO will in terms of issuing its building permit, which is exactly what happened.
Yeah, Terry.
That's what I see too, even in her own language. Yeah, section 1306 may give the planning board authority to invite professional input, be it architectural or traffic study. It gives them the authority to ask for it if they feel it's needed. But then for her to then conclude, it's clear the intent of the amendment was to require the planning board to commission a traffic and parking study. I don't see that. And even if it was required in that amendment, in that petition, it's CEO or planning board. So I don't think the planning board erred here.
Bob, did you have something?
Yeah, I think it's a real stretch to suggest that the Superior Court was defining which department of municipal government should be the appropriate one to look at this. They just wanted it looked at. And in fact, the CEO has the authority to do this. So making that decision that the CEO is the most appropriate individual to look at the traffic study seems to be quite within the purview of the planning board and the CEO.
All right.
I don't think no.
You can use the word voluminous instead of bifurcate.
Thanks. Trying to figure out how I can.
Well, the amendment, the ordinance, that everybody voted on, but it says there shouldn't be any off-site or shared parking, we've already put that off, or waiver of parking requirements. So it's still off-site, there is the off-site satellite thing, shall be approved unless it is supported by an independent traffic study prepared by a qualified, hired by the reviewing authority, CEO or planning board, and paid for by the applicant, which establishes that it's adequate, blah, 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 will not cause undue burden, safe, and all that. It doesn't say the planning board shall go, even the amended language doesn't do it, and it's not in the court order.
And can you clarify, you're reading from the
I'm reading from the Town of Rockport petition. This was the language that was put on the ballot for vote. This is the, with the signatures, and that was the exhibit we were given.
I think it is important to reference the land use ordinance too, because the languages are different.
True, exactly, yes.
There was some mention, and I can't find it, in Attorney Collins' work, that this was not an independent study. Did you guys remember that, and is that a factor?
It's a code enforcement officer issue.
yeah, is that,
But that's not
Next-
before
next
us
thing around.
to judge.
I think if I can clarify, what you may be referencing is there was an assertion that, I think it's Gartley, or if that's the engineering firm,
Yep.
that it said, I think she alleged that, whatever engineering firm did the analysis often worked for the applicant.
Leah, I
That
think,
was in the building permit.
yeah, I think you're on
No,
a
that's-
different appeal than we're
Yeah,
currently reviewing.
that's different.
Okay, that's a mistake on that one.
So it does sound familiar, but it's not tonight's.
The entity is a Goral,
that's the
Palmer,
this thing.
Goral
yeah,
Palmer, maybe.
Goral Palmer, yeah.
All right, so any further discussion on this matter? All right. I'm gonna have a coughing fit. Can you take over? I'll be right back.
Find my thing here. We are on number 5, correct?
Yes.
The applicant is prohibited from building the 26-room hotel approved by the planning board. And any further consideration of this project, even on remand, required site plan amendment showing the reduction of number of rooms from 26 to 20. Council, Mr. Duquette, do you want to?
Certainly. Again, and this was touched upon a little bit earlier, but the court took great pains to say several times that it was not, that it did not vacate the site plan approval. In fact, again, and I'm reading from the March 3rd, 2022 order on post-judgment order, where Justice Maloney stated, "No party has cited authority suggesting the plan had to be vacated to allow the planning board to accomplish the task required on its remand." And so again, and again, as Leah had pointed out earlier, the court even suggested that that the site plan approval was based on an exterior review of the project, and therefore the number of rooms doesn't really come into analysis.
Right. But the number of rooms is only relevant to the parking issue, correct?
Mr. Murphy?
I would say that the number of rooms is relevant to the building permit issue, because the way that the court framed up the two proceedings. One proceeding is site plan, and the other proceeding is the building permit. And the court went to great pains to separate the two, because it was addressing a legal argument that it rejected ultimately. But essentially, it said that site plan deals with the outside, the building permit deals with the inside. And there's a rhetorical question on page 20 of the opinion that said, surely no one can complain if the hotel decides to go from 26 rooms down to 20. It has nothing to do with site plan. Site plan is about the outside, building permit is about the inside. Now, we may personally have different opinions about that, but we got an order from the Superior Court telling us that's how we're to construe the ordinance, and so that these are two separate proceedings. So therefore, site plan does not need to be reapplied for or amended to reflect the change in rooms from 26 to 22. The structure is not changing, and any requirements under petition A and petition B can be addressed and have been addressed with the building permit process.
All right, thank you. Leah, please.
Mr. Chair, I just wanted to amplify on something that Attorney Murphy said. I think it's important, for municipal boards, particularly those who review, planning board decisions. I think what Attorney Collins was talking about, and I think she even cited a provision of the land use ordinance that basically says, look, you can't you can't build in a way that's inconsistent with an approved plan. And I think what Attorney Murphy is, and he can correct me if I'm trying to put words in his mouth, is to simply say that while the court's approach in that regard, in its order, is maybe somewhat unorthodox, it's the law of the case right now as we are, and so we need to basically deal with things as the court has directed us to do. So I think that, Dan, is that a fair summary of what you're saying?
Yeah, and basically, in support of its own reasoning, the court said that any reference to 26 rooms in the site plan process is just a repeat of what an applicant said, and it is not an element to be considered with respect to site plan review. That's from the case. So that's what we're directed to obey and implement.
All right, board discussion.
Just saying it a different way, this issue is not properly before us because the Superior Court did not remand this issue to the planning board for the very reasons council has just stated. They were concerned about the outside of the building, not how many rooms are in the building. And therefore, this is not a matter that's subject to appeal to the planning board, to the zoning board of appeals.
It sounds like the court has made the decision for us, by the way it's described.
And the room count is only relevant to section 800 parking, which is a separate thing and will come in under a different umbrella.
Max, anything on your side? No, I agree. So, I think that our council has an idea of where we are on this. It is 8 o'clock. We've been at it since 5:30. Oh, look at that, it's 8 o'clock. We have just a couple more things to go. Do people just want to push on through? Do anyone need a 5-minute break?
I'm good to go.
Push on through. Excellent.
It's a line from a Doors song, I think.
How's that?
It's a line from a Doors song, isn't it?
We are on number 6. The planning board erred in failing to consider the architectural harmony of the back harbor side of the hotel. And council.
I'm going to read the room here and take Attorney Hall's suggestion that, again, this was not an issue properly before the planning board on remand, so I don't think it would be an issue that the zoning board of appeals needs to take. If it, should it decide to do so, I think the planning board also appropriately resolved that issue.
Since you posed us a question, I'm going to be one voice in the answer on that. And I'm looking to Leah to help me out on this, but even if the Superior Court doesn't remand, I would think that it's not inappropriate for this board to weigh in on a question asked, even if there's no substantial legal push behind it. It's just from a personal satisfaction. Did they answer all my concerns, or did they address them? To take this particular point, number 6 out of 8, and to dismiss it is not, from a human standpoint, satisfactory to the person who made the complaint. So I'm wondering, Leah, help me out, because I've just dug myself a hole.
If I could interject something, I understand the human element of looking at this particular issue, but the court specifically found that the Friends of Rockport had waived this argument. And you can't revive it through an administrative appeal.
So we're going to start using the word specious then?
Specious is a good word.
Yeah, okay.
This would be a never-ending process if we allowed to do that.
Yeah, okay, so we'll get over to Mr. Murphy in a minute, but Terry?
And I've also found, via prior multiple meetings, many of these things that they're addressing were addressed by the planning board, were re-reviewed by the ZBA. Elements that relate to the rear are, the upper decks. They talked about lighting. We talked about noise, nuisance. We reviewed all that stuff. So it's not like all of a sudden somebody's discovered the back of the hotel. Oh my God, nobody ever. Yeah, lots of attention was paid to that by both boards, and I feel it was sufficient.
Anything on that particular detour, and then we'll on to Mr. Murphy. Leah?
Yeah, I did want to get some clarity. I think what I hear is being said is that, this was outside the scope of the remand. I think we discussed it earlier, that there is actually a specific, I think I read from the decision that there's a specific statement in the remand order, the December one, I think, that says that while the Friends of Rockport presented a list of objections relating to architectural standards, they now confine their challenge to the balconies that extend from every guest room on the front
side.
That's correct.
So I think that, I think it was mentioned that I think that the court specifically said, front facade, that's where we're going here. But I also heard other reasons that this board finds that ground is probably not something that you found to be substantiated. But I think I don't think any of the council had an opportunity to speak to. Let's hear from them.
Well, actually, we're going to bump over to Dan Murphy for a moment, and then we'll go to the council. Yeah, thank you.
Yeah, I just note that Leah's correct, that the court stated that the challenge was confined to the balconies at the front of the hotel. However, the planning board, in its opinion on Part 7D, did note that in the rear of the building, there are balconies or decks on both adjoining buildings, as well as on many buildings facing the water overlooking the harbor. I think there was discussion as to the balconies in general. So the issue, even though it may not have been properly preserved or part of the scope of the appeal, the planning board did address balconies in a very comprehensive way, front, back, in the vicinity of structure and so on.
All right. Board discussion. No need to discuss because it's out, all right? Number 7, the planning board erred in considering a fire escape and residential decks as being architecturally similar to balconies included in the hotel design. It is the number, size, location, design, and use and lighting of the balconies that made them dissimilar to any other decks or balconies in the visible surroundings of the hotel. Other balconies built after the hotel's approval should not have been considered. That's actually verbiage you were just working with.
I think the planning board, in looking at the prior record, determined that visually harmonious does not mean the same. And it also, as noted earlier, there's nothing in the ordinance which defined the vicinity, if you will, within one's eyesight while standing in front of 20 Central Street. It includes the neighborhood and surrounding buildings, and so the planning board properly did that and determined in this context appropriately so that the balconies as proposed are visually harmonious with the other decks and balconies in the vicinity. I'll also note that the property on the other side of the street, I believe 23, is not a fire escape. If it is a fire escape, I think it's probably in violation of a few codes, given the fact that it does lack actual ladder in which to escape from said fire.
All right, thank you, sir. Terry?
And I'd like to also comment that not only repeat that all of these things had been parsed through before by both boards. What I'm seeing here is this continuing note, and I see it sometimes in the court's judgment. They seem to be looking for either board to exercise more authority than what we're given. And the architectural standard thing can be tricky, I know, because I was on the planning board for 9 years. It at once is very specific in some areas and gives you but essentially, unless a town, and a town of our size wouldn't do this, wants to create a design review board, and that echoes this whole reference to professional input, with an architect and an engineer and a historical preservation person and maybe a couple of lay people thrown in for ballast. We don't have that. We don't have that level of scrutiny. We don't have that level of power that would have to be created. They're trying to lard our ordinances with greater authority than what we have, and were we to exercise that, we'd be overstepping our bounds. What it basically does, when I read our ordinances, is it's basically giving a board of a number of people to exercise their judgment within the limits that they're allowed, and we give it over to them to discuss these things, parse it to the extent that they can, and be as thorough as they can. But then in the end, it's up to their judgment. Is this, and balconies are a perfect example. One person's balcony is somebody else's, but the ordinance, you got to have a whole design review board to go into, well, this type of balcony shouldn't be allowed because both boards decided that it met the ordinances and that they properly exercised the judgment and discretion allowed them. And they can't really, at the same time, they can't overstep that. So that's what small town ordinances are like. Maybe in Simsbury, Connecticut, or Portland or whatever, those size of municipalities with the kind of detailed different types of neighborhoods that they have, they can sustain and it's proper to create a design review board. We don't have that, and that's what I always feel like they're asking us to do, is to step in and act as if we have that kind of authority and scope of review when we just don't. And we leave it up within certain parameters of a planning board to make those decisions, and then similarly for a zoning board of appeal to make the same kind of review. I hope that's not too soapboxy, but.
Well, it's, this was actually the point where I was leaving my soapbox too. Let me just interrupt for Mr. Murphy. I apologize, we stepped by you.
Nope, no particular comments on this one.
All right, thank you, sorry.
Mr. Chairman, I have one other point.
I think Max was gonna lean into that
No,
first.
I was just gonna say, I agree. I've run into that many times during this whole process where you're asked to review something that is so vague and kind of up to, and then for us to then try and bring it back into the appellate lens and say, okay, well, did they make a reasonable decision? It's a balcony hanging off the side of a building. I mean, it's kind of up to their discretion after that. And so I can't say that their decision was unfounded. You know?
Just going back to the Superior Court, they ruled that their review of decisions of the planning board was deferential. They just needed more fulsome review of balconies in the area. And that's what they got from the planning board.
Yep.
All right.
Yes.
Anything else?
No, I agree with all this. I think when you look at the minutes of the February meeting, planning board meeting, everything the court asked was addressed, including the appearance, describing the appearance, which is what they wanted, including having some architects put in their feeling about exactly how the decks looked, and I can't see anything else that the planning board could have done that they haven't done at the request of the court.
All right. Anything else about that, on that? Coming right up. Sorry, help me out. Are we doing number 7, or are we down to 8?
Nope.
No, you're on 8.
Yeah, 'cause it's
I think
6.
we're on number 8.
6 and 7 are similar. Thank you. So number 8, the final, the planning board must revisit its findings on scenic view, which is one of the considerations required by the architectural harmony standards of the land use ordinance. The required reduction in room numbers changes the analysis of whether the building design minimizes the impact on the scenic views to the extent reasonably practical. Council.
Yes, and I might be restating and reiterating things, but because the March 2nd, 2022 order is not before this board, I'll read it exactly from it, so it's in the record. And again, Justice Maloney states, the issue of scenic views was considered and analyzed at length in the court's decision. AP plaintiffs' arguments renewing their request for intervention on this basis do not persuade the court its initial decision was either incomplete or an error. This request for relief must therefore be denied.
All right. You use that must word. Mr. Murphy.
No, I agree. Even in the original order, it's very clear that the court was deferring to the judgment of the planning board and basically said that it could not override the prudential decision of the planning board. So I think that's very clear.
Board discussion?
So the court found for the town of Rockport and 20 Central on the issue of scenic view. So it's impossible for the Friends of Rockport to appeal it here.
And I just want to say to, not to be overly critical, but even the reference by council, it's a little bit out of context, because I'm doing it right now. You put up a PDF of the land use ordinance, you pop in scenic for find, The majority of them, of those references do not, they have to do with natural resources or cluster development or, that kind of thing. And the one thing that she's quoting from actually comes from, I have a note, page 120. Hang on just a minute, it'll go fast. It actually is yoked to, it doesn't, she's leaving out the part that, I'm gonna read from my notes and I'll try to find the actual one. But that it has to do with, if you're looking at things that must be for like of historic importance, scenic beauty, or irreplaceability of natural areas, this is a commercially zoned downtown area. I don't know what natural area we were supposed to, or the scenic view, there's water view, expansive water views on one side, expansive on the other. This is actually a very limited swath of commercial buildings. So I just, I looked, I did a search for scenic view, scenic. I just couldn't find anything compelling in our land ordinance that I felt really was relevant to that particular area in downtown Rockport. It's a commercial zone, that side of the street. There's plenty of water view all around it. I mean, it's not like that development goes on for, a couple of thousand feet. I just don't get the argument at all. And I just don't, and I find nothing, whether we're dealing with it with the court remand or whether we're reviewing, I think the planning board has turned over every stone, and I simply can find nothing in the land use ordinance that would appropriately yoke preservation of scenic view to this specific section of downtown Rockport that we're talking about. Because they had the legal right to develop it. It's a commercial area. And there also were other, there's other ways to preserve if they felt that was, I believe a number of years ago, maybe 20 years ago, some concerned citizens bought some section around the corner on the other side of the bridge, I think where the overlook is. They just banded together and bought it so that they could preserve it and give it to the town. I mean, there's ways of going about that, but I just don't see this as being appropriate applied at all anywhere I can find in the land use ordinance.
I think Mr. Murphy has something to say. Is that a hand I saw?
Nope.
Oh, I'm sorry. You were gesticulating to the music. All right, any other soapboxy things?
I have a question for Leah, if I could. Leah, as you know, I've been in court and arbitration panelists a number of times, and courts and arbitration panelists have the authority to grant attorney's fees and costs for behavior which is vexatious, duplicative, and in bad faith. And certainly that's something we should consider here if we have the power to do that. When you come back to us with a draft of our findings, can you give us an opinion as to whether or not we have that power?
I can give you that opinion right now. Zoning boards of appeal, like all municipal boards, only have such authority that's specifically vested in them in ordinance or state law, and there is no such authority granted in the ordinance or in state law. And I will say, interestingly, even the court on ADB, I mean, I guess the court retains some discretion with respect to, this issue, but even on ADB appeals, they don't have the discretion to award attorney's fees, or they certainly don't, at least under Rule ADB, they don't. So I would say right now that I do not believe that the Zoning Board of Appeals has any authority to issue that kind of relief.
Well, it's unfortunate, since the town of Rockport and its people have had the burden of paying for this litigation, which is totally unnecessary, in my opinion.
And play devil's advocate, as you were saying. We certainly simultaneously recognize the right for anybody to come forward who's an aggrieved party and to go through the proper channels and to be determined in their efforts.
I second that.
So, we do have minutes that we need to review and approve, but it,
Were we going to invite
I'm sorry,
public comment?
well, yeah, absolutely, if any public comment wants to wrap it up. Given none before, I decided.
Well, you asked me to nudge you,
Oh,
not,
no,
and remind you, so.
we invited the public to, that was our voluminous public.
Oh, you did do that, and the train went so fast, I forgot that we did it. I'm sorry.
Gotta get
Yeah.
up, could you come to the microphone, please, thank you. And of course, remind us of who you are and all that good stuff.
My name is Claire Tully. I'm a Rockport resident and president of the Friends of Rockport. And I would just like to just say a couple of things briefly. The first is, with respect to what Mr. Hall just raised, a lot of the fees that have been expended on this case have been spent in an attempt to overrule a majority of vote of the public on these two petitions, which were ultimately upheld. So I think to say that that was vexatious or frivolous is really very unfortunate. And secondly, I'd like to add on the subject of scenic views. Scenic views do apply to the downtown area. There's no exception for scenic views. And scenic views are very important and dear to the residents of Rockport. It's rated one of the highest things in the comprehensive plan. And once views are extinguished, they are gone forever. So it's not a trivial matter. If a view that has existed for well over a century, as a big portion of that view did, is extinguished. So I would respectably differ on that. And I'd also like to thank all of you for the effort you put into this. I mean, clearly a lot has gone into it and we appreciate it. But again, these matters are not trivial. Thank you.
Thank you, and thank you for reminding me to give them the opportunity. Are there any other matters that are before us with respect to 20 Central? I don't think so, so we just have, thank you all very much.
Mr. Chairman, if
Oh.
I might just, little logistical question. While we are here and assembled, mostly anyway, I know Attorney Collins is not here, but I think
When
it
can
would
we
be
meet?
helpful if, I don't know if your board meets sort of as needed, or if you have, the first and whatever.
We meet regularly irregular.
Yeah, right. So while everybody's here and attorneys are here and the board is here, perhaps we could talk about when we can reassemble to discuss draft findings as well as to hear the continuation of the second appeal.
So my first question would be, what do you and Ben need for time to be able to do that?
That's a good question. I'm going to email him right now and see. I'm thinking, would 2 weeks be something that would work? I think that's probably realistic.
Hey, Orion, I forgot to ask you to sort of prep a couple of dates, but, so Leah, mostly, we're on a Tuesday night right now. We mostly meet on Thursdays when we meet regularly. But I think that this was an opening in the Opera House schedule. But I'm looking to Orion to see if he can help out with that question.
Sure. Just give me a second.
Wake up.
And I mean, maybe we could do this offline, but I thought that it might be helpful if we're all here.
It
and
makes
everybody's
sense.
got their calendars.
Yeah. So the biggest one that'll take place in the Opera House is the planning board on the 26th. And I'm not seeing any others other than the 16th. That's a Monday. That's got a select board meeting.
Does Tuesday, the 24th, is that open?
That is open on the main calendar. Let me look at the Opera House.
Somebody in this room has a birthday on that day.
Can I suggest, and I'm sorry to put a wrinkle in things, that week is just crazy. I have
Oh.
several meetings that week. Is it possible that June 2nd, I know that's pushing it out a little bit, but would June 2nd work? And I'm hearing from Ben that will probably work for him.
Works for me.
Oh. I hate to be a poopy. I can make that work. I can make that work.
Yeah. June 2nd is open on the town calendar side.
Yep, that works for Ben and myself. And, you know, obviously, I don't think that this is something, and I shouldn't say this, but in most circumstances, draft findings, really, it's not a public hearing, it's just simply for the board to go through them. And I think what I would suggest, and what is my usual practice, is that just so there's no surprises, that I would circulate the draft finding in advance of the meeting and copy council, that if there was some egregious thing that folks are, you know, upset about, that I think it's important for the board to know about that before the meeting. So I will undertake to do that and say, you know, by, say, Monday the 30th, we'll get those circulated.
All right. And Monday's is Memorial Day, just as a reminder.
Oh, right, so the 31st, would that be acceptable to have those? I mean, we can endeavor by, it's easy for me to tell Ben what to do when he's not here to defend himself, but how about I say that May 27th, we will circulate those findings. I think that gives us time.
Perfect.
I have a question about, Mr. Chair,
Yes, please.
the June 2nd date. So clearly, we're going to go over our findings of fact and vote on them, possibly, you know, modify, put them in final form. Are we also on that date going to then address the building permit issues, the CV as well? That will be,
So roll right into the second appeal.
right. I mean, we can't put that off forever. I mean.
No, and nor do we want to put it off forever.
And I don't think the finding of facts thing is good, not gonna take forever.
Yeah, I think that in the interest of efficiencies, we're
Yeah.
here. I think that makes sense.
Okay,
Okay.
good.
I will have to clone myself, but we'll do that. All right, and we will let you know as soon as possible if for any reason there's a compelling, if Scott's not available or something like that. But we hope to have the speed of justice. Oh, Leah, you are muted.
I'm sorry, Orion, can I ask you perhaps to reach out to the powers that be in town, Mr. Bickford, and sounds like we know that the space is available, but I don't know who is tasked with making sure. I mean, I guess, Dan, would that be you if I believe you're representing the code officer in the appeal of his decision, right?
Yes, yeah. I can confer with the CEO and the planning department to see about availability.
Great. Thanks. And would you mind just circling back with me and copying Chairman Parker on that so we know where to go?
Sure.
Great. And I'll make sure that Kristen is aware as well that that's the targeted date.
Okay, very good.
Great.
All right, excellent. Thank you very much.
Thank you.
And so for the board, we need to approve the minutes of February 2nd, 2021, which was a administrative meeting where, for better or for worse, elections were held.
So moved.
And minutes. So we have a motion, second for approval of minutes. Discussion. You can, all voting yes, raise your hands. 1, 2, 3, 4, 5, and all raising not their hands for nays would not be here. Thank you all very much. And that
Hey,
concludes.
Jeff,
Yes.
real quick, just for clarity, there was a continuance issued, right, for this meeting of the board?
There was, oh, that's a very good point. Well, there was, for the second part of it, and that will be continued to the meeting we just spoke about.
Right. So there was just a formal group consensus that, I know a date was discussed, I didn't know if there was a formal vote that had to be held, so.
No, that's a good question. Just for purposes of CYA,
If you don't
I
mind.
move that we adopt the date of June 2nd for the continuance of the issue of the building permit.
Second.
discussion? Yay?
Am I involved in discussion? Oh,
Yeah,
Yeah, that's right.
you're back in.
Back, we need the 6th vote.
for discussion? I won't be here on the second, graduation stuff. So,
Right.
but considering,
Yeah, considering this step
considering
down.
I'm kind of a non-entity on that, so
All right,
works for me. I'm just gonna miss it.
yep. All right.
Have to
well,
watch the
we will miss
recording
your-
later.
Your smiling face.
So we've all voted?
We have raised our hands? We have raised our hands. Okay, 6-0. Let the record
And
show.
I was really hoping we were, because I'm going to be out of town for a week,
Starting right after?
June 10th through the 19th,
So we close out this meeting before you broadcast your personal,
No, I'm just saying, I was concerned that if we were then getting into June, that I might not be around, and so,
yeah, I think this is a good balance between
Yeah.
getting it done and
Yep.
waiting too long.
and they shouldn't have to wait.
I will be done June 17th.
Done, that sounds
Moving
very.
out of town, just to get off the board.
So you really are gonna do that? Oh, which is to say, if anybody is lasting on this meeting up to this point, if you are interested in this, as Frank Zappa says, does this kind of life look interesting to you? Please let us know. Thank you. All right.
I think we've made progress, though. I think tonight's meeting was, just moved along and went very well, I thought.
Well, not making a motion on every single,
Yeah.
It's different.
man, that speeds things
Yeah.
up.
Bruce, I think you can close, a motion to adjourn.
So moved.
Second.
Second.
Vote.
Right?
Thank you, Bruce.
Forgot you were sitting.